This honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first case is 23 CF 331, Gregory Philip Wood versus the United States. Counsel, whenever you're ready.
Good morning, and may it please the court, Fleming Terrell on behalf of appellant Gregory Woods. I'd like to reserve 2 minutes of my time for rebuttal. Mr. Woods' felony conviction for tampering with physical evidence should be vacated outright because the prosecution's evidence that he briefly and almost reflexively stepped on a plastic baggie of suspected drugs that fell from his waistband during a custodial search was not sufficient to prove that he physically altered either the bag or its contents within any definition of that term, much less within the meaning of the tampering statute by reducing its evidentiary value.
But counsel, why do you say that he, if not reflexively, stepped on the bag? Does the evidence support that?
Yes, the evidence does support that. If you watch the video, you can see it's a very quick movement. And that's consistent with the officer's description that as this item fell from his waistband, he stepped on it or stepped near it. And the trial judge certainly took that away from the testimony because at the sentencing, the judge actually sentenced Mr. Woods to time served because the judge said with regard to the tampering, that was, you could see it in the video, a moment of panic, not an act of premeditation. So it was, I think reflexive is an accurate description of the way in which this step occurred. And that really goes to sort of the fundamental unfairness and the fundamental inconsistency with the purpose of the tampering statute here to charge this act as a felony. I want to address the question of statutory interpretation and of remedy, but I think it makes sense to start with the insufficiency of the evidence to prove that Mr. Woods altered the bag at all, that is, changed it at all, because the case can be resolved based just on that. The government concedes that in order to secure a tampering conviction, it had to prove that Mr. Woods caused some physical change, either to the bag or to its contents. But the prosecution's evidence below can't clear even that low bar. The government's primary theory is that jurors could have found that the outside of the bag was dirtied or scuffed, but that's simply contradicted by the record. The only evidence of the bag's appearance submitted into evidence below was the photograph, a blurry photograph that doesn't show any sign of dirt or scuffing on the outside of the bag.
So counsel, what about this loophole that your opposing counsel brings up in briefing that, oh, well, that just means somebody with something has to move so quick that there is no evidence of it ahead of time? Does that just create an impossibility for the government then under your theory to ever prove anything under alter?
Certainly not. And there are certainly ways through circumstantial evidence to show that a change has resulted from the charged act of tampering. So it just sort of as a prefatory point, I'll say here, you don't even need to get to that on the question of was the bag dirtied, because you have evidence of what the bag looked like and it wasn't dirtied. So it doesn't really matter what condition it was in before, because it was still in that good condition after. I think that concern that the government has raised about whether there needs to be affirmative direct evidence of what the object looked like beforehand is really only relevant to this theory that sort of floats in one sentence in its brief that maybe the form of the substance inside was changed in some unspecified manner. The only manner I can think of is that it might have been crumbled. And with regard to that, I think the Texas cases that we've cited are helpful on this point. There are circumstances and evidence in which it is reasonable to infer that a change has occurred by virtue of the condition of the object post-act of tampering, post-charged act, and the nature of that act. So the example in the Texas case Stammen, where it's citing another earlier unpublished Texas case, was of a defendant who tossed a bag of drugs while in flight from police. The bag is recovered, ripped open, the drugs are gone. And the court says, well, jurors could have inferred that because that bag was not in a functionally useful state at the time of its recovery, no one would have been carrying their drugs around in ripped open bags. Jurors could rationally infer, even though nobody testified about what the bags looked like before they were tossed, that the ripping must have occurred at the time of the act of tampering. And the court in Stallman said, we don't have that here. You'll remember Stallman was a case where there was a pill bottle tossed over a hedge onto grass after a rain, and the label was smudged. And Stallman said, even though we have sort of a mechanism for how that act could have caused the smudging, it is speculative. It goes too far to infer that it did cause the smudging because we neither have evidence of what the pill bottle looked like before. So we have no evidence that the pill bottle didn't have a smudge label before, because unlike a ripped open bag, a pill bottle with a smudge label is perfectly functional. So you can't infer that the defendant wouldn't have been carrying it around in that condition to begin with. And we don't have evidence that the proposed mechanism for how the damage could have happened was actually in play. That is, that the ground was actually wet at the time. And the exact same analysis applies here.
Well, I wonder if it does, counsel. I mean, you're quite right that there was no testimony about what the bag looked like before it hit the ground and the defendant's foot either stomped on it or scraped it across the ground. But I wonder if it wasn't reasonable for the jury to infer that a plastic Ziploc bag of the kind we all are familiar with, if scraped across the ground with someone's foot, wouldn't get scuffed up. And I have to say that looking at the photo of the bag in the exhibit, it does seem scuffed up, crinkled, wrinkled. I don't know what the right word is. And you might say, well, it could have been like that at the time it fell, and that's quite possible. But it also seems quite reasonable to me to infer that even a crumpled up bag, if dropped on the ground and stepped on and scraped across the ground, would have added to it a few more crinkles, wrinkles, scuff marks, whatever. Why is that not a reasonable inference?
I think a couple of evidentiary reasons why not. So first, in fact, there was no testimony that the bag was scraped across the ground. The testimony that the government relies on for that is that of Detective Love, who, after watching the body worn camera video where you cannot see what happens on the ground, right, says it looks like he tries to scrape it on the ground. Detective Love also was not able to say whether his foot was even on the bag at the time of this
Right,
backward
he said his foot
motion.
was near or on, that's
Near
true.
or on. So he said, and he says he scrapes it, he pulls his foot backwards, right? Like he was trying to scrape the bag on the ground.
But the other officer, Tran, testified, or Detective Tran, I guess, testified that he put his foot on top of the bag. And so the
Yeah.
jury could believe one or the other, and so.
Right, but Officer Tran didn't describe this backward scraping motion, right? And so, this all happened fast. It was in a jumble. And I think it would be, it would cross the bounds of reasonable inference and go into the territory of speculation to sort of combine these two together and say at that moment that Officer Tran was describing the foot being on the bag. And remember, Officer Tran said, as soon as I saw that, I pushed him off of it, right? And you can see in the video that officers tackle him, that's the moment at which Detective Love is talking about seeing this backward motion, particularly when Detective Love was, sort of careful not to say that he saw him scraping the bag across the ground, just that he tried to do that. Also, and I'm sorry, Justice Thompson, I'm thinking of your question, and there was another important evidentiary point that has now escaped me
Well, we
with.
can add it when you think of it, sorry.
With the question, the scuffing or like the folding and crinkling to the outside of the bag. I think if you look at the video, when you see what falls from his waistband, it's not an open like bag flapping in the wind. It is wadded up. It's a little ball. So I think, it appears that has been opened up in the evidence room. There was no testimony about how it got into that state, but I don't think you can infer that the step caused that unfurling of the bag, and any crinkling, I think, could reasonably be attributed.
It's hard
to
for
the-
me to think that if indeed someone scraped a bag like that across the ground, that it would not have been altered, changed in some way, made more crinkly.
Right, which I think is why it's critical that there was no testimony here. There was no evidence here that he not only tried but succeeded in having his foot on the bag and scraping it across the ground. And likewise, you can't infer from that mere act that there would have been any damage to the substance inside the bag. And I think this may be the point at which to sort of turn to the statutory construction question, because I think that very example underscores how absurd the government's interpretation of alters is in this case. They're saying that the legislature intended to make it a felony punishable by 3 years in prison to scuff the outside of a plastic bag of drugs in a way that is a purely cosmetic difference that has no impact on its evidentiary value.
Well, let me ask you about impact on evidentiary value. Do you conceptualize that as a generalized impact as to any potential charge whatsoever? Or is it the evidentiary value to the charge that the U.S. Attorney's Office brings?
I think it would be, I think because the statute requires knowledge by the defendant that an official proceeding was likely to begin, and an intent to diminish the evidence's availability or the object's availability or integrity as evidence for that official proceeding. It couldn't be evidentiary value for any possible conceivable criminal offense. It would have to be something that that a defendant in that case could be expecting the official proceeding to relate to, if that makes sense. So I think it doesn't have to be the precise charge that is actually brought, but I think the entire universe of criminal offenses is probably too broad.
You know,
if that
you
makes sense.
make the point in your brief, it's a good point that in terms of reducing the evidentiary value or affecting the evidentiary value, that assuming the bag was scraped on the ground or the stomped with the foot, that those actions didn't change the substance of what was in the bag or change the weight of what was in the bag or didn't destroy the bag. So in that sense, there was no impact on evidentiary value of the bag and its contents. But I was thinking about the fact that not too long ago, we heard a case in which a defendant, like the defendant here, was charged with possession with intent to distribute. And the defense offered was, well, yes, the bag of drugs was found on me, but I wasn't intending to distribute. I saw it on the ground and I picked it up, and that's why I had it. And in that particular case, the fact that the bag was dirty and scuffed up supported the defense and detracted from the government's case, i.e. it affected the evidentiary value. So I think you may be looking at evidentiary value in a way that's a little bit too narrow. What do you say to that?
Well, I'll say to that I think the government has effectively conceded that the alterations it posits in this case did not impact the evidentiary value. Because the government did not make an argument that by scuffing the bag, Mr. Woods reduced its evidentiary value, made it hard to prove its case. And it hasn't argued that in its brief. To the contrary, it has said, yes, these alterations are to the scuffing to the outside of the bag or a change in form to its contents. And there's no need to show more because the statute does not require a change in evidentiary value. So I think the government hasn't raised that argument, and this court doesn't need to grapple with sort of that type of question in this case.
By the way, I was looking at the jury instruction, and the jury instruction on the mens rea element was it was not the precise statutory language. It was something to the effect of with the intent to reduce the evidentiary value. And my question is, where did that language come from? I take it that the parties agreed to that. The statute talks about the integrity of the evidence, and I wondered why reduction of evidentiary value instead of integrity ended up being the instruction on mens rea, because it sounds like the argument now is to draw some link between that mens rea context and what it means to alter, because you're now arguing that the meaning of alter is to reduce the evidentiary value.
Yes, I think I would have to look at the Red Book to see if that's the standard Red Book instruction or not. I don't recall there being any discussion among the parties about departing from the standard instruction. And I think that's a fair gloss on what the statute means by integrity of the object as evidence for an official proceeding. That means its value, right? Impairing its integrity would be reducing its value as evidence. And I don't think that comes just from the mens rea element of the statute, but also from the remaining context of the statute. So the other acts that are all acts that do reduce the evidentiary value or completely destroy the evidentiary value or availability of an object, mutilate, destroy, conceal. And also the legislative history, where it's clear that the council was concerned with acts that actually impact the object, right? Acts that destroy evidence, not attempts to destroy evidence. And you can see that distinction with the tampering with an automobile case that the government relies on in its brief, where there the legislative history revealed a legislative concern with criminalizing attempts to break into automobiles, not just successful break-ins.
You think it would not be fair to construe this statute as the council wanting to protect evidence, kind of prophylactically trying to punish conduct that would?
Yes, I think this council was trying to protect physical evidence from
Right.
actual damage. And it chose not to do that by penalizing failed attempts to damage evidence. And we know that both because of the language that's in the statute, because of the mens rea, and because we can look at what else the council was doing at the same time, which is the obstruction statute, the sort of witness tampering statute, where the council very intentionally included endeavors language, right? With the knowledge, and you can see, I think we quoted in our opening brief from the committee report, that the council was very well aware that that language had been interpreted to encompass attempts, failed attempts. And it chose to use that language in portions of the obstruction statute and did not use that language in the tampering statute.
But how do you think the mens rea element of this statute supports your interpretation?
I think it reflects what the legislature was focused on, right? The harm that the legislature was focused on. Now, there's also, in the Webb case that the government submitted a 28K letter about, I think mentioned some of the legislative history that that intent is really key to the crime of tampering. And I think a big piece of the intent there, the mens rea element, was to distinguish innocent acts of destruction of objects that could be evidence. So, destroying documents under a standard records retention policy without the intent to impede an official investigation. So that is sort of the other role that mens rea is playing. And that's why the legislature and the court in Webb said, the intent is really the key to this offense, is because it distinguishes innocent acts of destruction or concealment, but there first has to be an act of destruction or concealment. The legislature— Alteration, destruction, concealment, mutilation, right. The legislature did not say anyone who attempts to alter or endeavors to alter, as it had just said in the obstruction statute, right?
What's the difference between altering and mutilating?
I don't disagree with the government that altering implies a lesser degree of physical damage than mutilation. I think—
Why is it a lesser degree? I mean, what if I take a document and it's material that it has a certain year in the document?
Yes.
And I change, I very carefully white out and change the year. I've altered the
Yes.
document. I
Yes,
haven't mutilated it, but it's
Exactly.
very important that I have changed the year because now whatever conduct where that year was material is no longer, it doesn't show that I'm engaged in insider trading anymore because the document is post dated. Seems like altering has a very specific purpose and use
yes.
in the statute and doesn't indicate a lesser purpose than mutilation.
Absolutely not a lesser purpose. And that's exactly the example that I was going to use. And it's the example the government uses in its brief. And I think it's telling that it's one where that alteration, although the degree of physical change to the object is less than a mutilation, is sort of what I was trying to say with lesser degree. You've barely made any physical change to the object, right?
I mean, the point is to make as de minimis a change as possible so that no one notices.
Right.
Can we go back though to the beginning of your argument where you said, look, the government's argument is that altering means change,
Yes.
right? Some physical change.
Some physical change.
And you say we win under that theory.
Yes.
So why do we have to go further to sort
don't.
of intuit what alteration means in the minds of the council when it enacted the statute?
You
Okay.
don't need to
Okay,
go further.
so assuming that's what we did and assuming we agreed with you, the government says, okay, but you should enter a conviction for Mr. Wood on a lesser included.
Right.
And you disagree.
Yes.
Can you talk to us about why that would not be permissible?
Sure. I think bailing the government out of the consequences of its strategic decision to sort of shoot the moon on the completed tampering charge would not be just in the circumstances as required by the enabling statute by 17-306 for three reasons. The first is that it would do undue prejudice to Mr. Woods because it would deprive him of the benefits of his chosen trial strategy and the opportunity to tailor his defense to the attempt charge. Second, because it would foster systemic injustice by incentivizing the government to over prosecute what is legally accurately described as attempt cases as completed offenses. And third, because in this case, the government seeks an attempt conviction, not an unarmed version of the offense, not a lesser degree of the same offense. This case doesn't meet the requirements that this court articulated in Robinson and in Bailey that the jury actually did find all of the elements of the lesser offense. So here the jury, an element of attempt to tamper is an act that came dangerously close to committing the crime. The jury, while we don't dispute that there was sufficient evidence for the jury to make that finding, the jury was not asked to and did not make that finding. The finding it made that Mr. Woods in fact changed the evidence was based on insufficient evidence. So if they got that wrong, we can't draw any inferences about what they would have done had they been properly executing their duty to hold the government to its burden of proof and been confronted with that element of the
I'm not
attempt
sure I'm
charge.
following that argument. You say the evidence was not sufficient for the jury to find the completed act of tampering.
Correct.
But they did find the completed act of tampering. And you're saying that we can't know that they would have found that the defendant came dangerously close if permitted to find that?
That is what I'm saying. And I
I don't understand why that would be.
I think the distinction is, for example, in Robinson, where there were armed offenses charged, right? And the jury found that those offenses had been committed and found the armed element. And the error infected only the instruction on the armed element. There's no speculation required to conclude that the jury made all the necessary findings to conclude that the unarmed offense was committed. Here, the jury simply wasn't presented with the question of whether there was an act that was that came dangerously close to altering this substance in any way.
Is the difference that we have said in cases where there's been instructional error that you can enter a lesser included, but we've not done it in sufficiency cases?
Well,
Is there a line
Bailey,
there?
Bailey was a sufficiency case, but it was not contested on appeal.
Right,
I've
where
looked
the
at the brief.
judicial mind has been focused on it.
That's
We
absolutely
have
right.
not permitted it,
I think, I don't know of a case
or
where
we've
this
not
court,
endorsed it.
I don't know of a case where this court has endorsed it. Many courts in other jurisdictions have said, no, under no circumstances will we ever remand for entry of an uninstructed lesser included. This court said in
In a
Robinson.
sufficiency posture.
Many of those in a sufficiency posture, yes. So sufficiency is a component of it. I think the fact that it's an attempt charge rather than, a lesser degree is also an important component of it, but you don't.
Why is that? I mean, I'm familiar with, our cases, Jones being one of them, talking about how you have to have a heightened mens rea for attempt. But this seems to be one of the statutes where you do have already a heightened mens rea, right? That the intent to impair its integrity or availability for use in the official proceeding.
Well, I think because in a case like this, where it is the act is what is infected with the finding on the act element is what is infected with the error, and the jury was never asked about the attempted act, you can't, there just is not a finding. And I think that's a problem. But even, sort of taking a step back from that, just the undue prejudice to the defense in this case is reason to distinguish Robinson and not to grant the government.
How
this.
might the defense have been tailored if the lesser included had been charged?
So if you look at the defense closing argument, it was focused on knowledge of an official proceeding. It sort of said, how's he going to know in this moment that an official proceeding is likely? And most importantly, the act of alteration. The defense said, this 1.2 grams of something, what is it? Where is it? How can they claim it's altered in this evidence tampering charge when they haven't even brought that evidence to you? The defense didn't talk about the intent that's required both for attempted tampering and for completed tampering. Didn't talk about the intent to interfere, right? We focused on the act because there was insufficient evidence of the completed act of alteration. So we would have tailored our arguments differently and our presentation of the case differently had attempt been on the table. And sort of more fundamentally, both parties made a strategic litigation choice here, right? And that choice was, we're going to shoot the moon. We're going to go for just the greater offense. And the government strategy there, when it does that, is to say, we're hoping that the jury is going to overcome any doubts about this evidence of the greater offense and convict, rather than let the defendant go scot-free when there's reason to think he did something wrong. And the defense strategy there is to bet that the evidence is not sufficient for the greater offense and count on the jury to hold the government to its burden. And the defense is always bound by the result of that strategic decision. If the defense makes that gamble and loses, and the jury convicts on sufficient evidence of the greater offense, we cannot come to this court and say, well, please, we wish we'd done it differently. Please give us the lesser included instead. Please convict us of attempt instead. But the government would be permitted to do that if this court granted the lesser included in this case. So basically, the defense has already incurred the risks of this strategy. The government ought also to be bound by the risks of its strategic choice to only attempt a conviction on the greater offense. And there's also a systemic problem, particularly in attempt cases like this, because it will incentivize the government to overcharge and over-prosecute failed attempts as completed offenses, safe in the knowledge that they can always request the lesser included after the fact. And we just don't think a functional adversarial system justice can work when one party is bound by its strategic litigation choices and the other party, the repeat player, isn't. So both for those individual prejudice to the defense reasons, for the systemic reasons. And because neither Robinson nor Bailey, the cases the government relies on, are on point with this case, we think this court should remand for entry of a judgment of acquittal on the
And they're
tampering
not on
charge.
point because
They're not on
you
point.
said, but tell me again, please.
They're not on point. Well, for one, Bailey, it was not litigated in Bailey. So while the court granted the entry of a lesser included offense on remand, that was not something that the appellant had opposed in that case, and that was not something that the judicial mind had been focused on. So it's really not precedential on the point. Also because neither case involves an attempt, right? Both cases involve a more secure conclusion that the jury had in fact found. And in both cases, this court said this was a necessary precursor to granting this kind of bailout for the government, that the jury necessarily and actually found every element of the offense. And it simply wasn't presented to the jury here. And that fact, I think, supports a stronger conclusion that what the government was doing here was strategic. So in Robinson, for example, neither party was strategically asking the court to give an inaccurate while armed instruction, right? That was an error that was unplanned and didn't play into the trial strategy. Here, clearly, both parties decided to take their chances on the greater offense, and the defense is unquestionably bound by its choice. The government should be too. So for all those reasons, we would ask this court to vacate the completed tampering conviction and remand with instructions to enter a judgment of acquittal.
Thank you, counsel. We'll let you sit down. We'll give you a couple of minutes for rebuttal. And
Thank
then
you.
we'll hear from the government.
Good morning. May it please the court. Kevin Burney for the United States. This court should affirm Mr. Wood's tampering conviction because a reasonable jury could infer that his actions would have altered the bag or its contents.
So the government concedes there's no actual evidence, testimony about the evidence being under the government's definition of alter being changed.
I would say there's no direct evidence, correct?
Right.
I mean, I
Right,
would.
there's no testimony that the bag had changed or that it looked different after he put his foot on it or nothing of that sort. So it's all inferences.
That's correct.
Okay.
It's essentially, I would describe it as inferences and circumstantial evidence. So, and obviously the offense is captured on video. So,
I mean, I guess I do wonder, there is the testimony from Detective Tran in the February 7th transcript at page 78. And he's asked to identify the substance. And he says that the photograph that he has shown is the white rock-like substance that he previously testified fell to the ground. You
That's-
sort of, I mean, the implication is it's the same thing, right?
Yeah, he
I mean, he
identifies
has
it.
an opportunity there to say there's something different and he doesn't say anything.
he could have given more detail perhaps. I remember that passage. As
More detail. I mean,
Yeah.
no detail, right? Like
But-
he just says, yep, that's it. That's the bag.
But I remember, my memory of that passage is that Detective Tran is essentially just authenticating the photograph. So he's saying, yes, this is the bag that we recovered, right? And it is unclear from the testimony whether, what the bag looked like beforehand and what it looked like afterwards. There's not that.
Well, it's not unclear. It's just, it's never explored. Like the government doesn't engage in that line of questioning at all, right? And
It-
government's witness, government's burden, and the government doesn't ask.
It doesn't ask those questions, that's true, although I would note from the video, like, it would be very difficult for the officers to have seen the condition of the bag before it falls to the ground.
Which I find a curious admission from the government. How on earth could these witnesses have known what the bag looked like and seen it and known that it had changed? But let's ask the jury to infer that that happened. I mean, that seems
Well,
not how this is supposed to work. We don't have any evidence of it. and we couldn't have possibly known, but please let them speculate as to the condition of the bag and how it changed.
But I think the tricky thing with this case, because the incident happened so quickly, is
But what
it's not just, in this case, I would say it's not just trying to look at a picture, even assuming this was possible, of the bag beforehand and the bag afterwards. Because it falls to the ground too quickly, you have to draw some inferences about how it would have been altered by Mr.
Why
Wood's
do you have to draw the
actions.
inferences? I mean, the government is sort of suggesting that this is a crime that is being taken away from them from prosecuting. And my understanding of how this works is that the government has to have evidence and then it charges based on the evidence. And if the government doesn't have the evidence, then it doesn't get to bring the charge. And there's nothing that's been taken away from them. They just don't have the evidence. But why is what I'm saying incorrect? You are conceding the detectives couldn't possibly have seen this evidence before it fell to the ground. But let's ask the jury to assume or infer or speculate that the evidence changed.
Well, I'm saying
Why is what I'm saying incorrect?
I think we're not relying on sort of a snapshot of the bag beforehand and afterwards. I think what we're relying on, what the evidence is Mr. Wood's actions, which would inherently alter the bag. And that evidence is shown through the video and the testimony. So that's the evidence.
Alter the bag. Okay, so, I mean, there's no evidence about the nature of the bag, right? I mean, am I supposed to, like, you know, the Ziploc bags are quite sturdy these days, although I'm not sure that this is even, I don't think there's any evidence that this is a Ziploc, right? Let's take the bag out of it for a second. I'm stealing diamonds. I have diamonds in my waistband. The police stop me and get the they pull me aside, they're searching me, the diamonds fall out, and I put my foot on the diamonds.
So in
Diamonds are known to be quite hard.
right. No, definitely. So in that case, I think certainly a reasonable jury could acquit because the diamond is much harder and it would
Okay,
be
I've never
difficult.
touched a piece of crack cocaine before. I have no idea how hard it is. So how am I supposed to know? There's no evidence in the record about crack cocaine and how hard it is. And I put my foot on a rock of crack cocaine.
Right.
How am I supposed to know that the crack cocaine has altered?
Well, first of all, there is a picture of the cocaine. And so the cocaine is somewhat crumpled up, but also the bag is crumpled up, I think, as has been noted.
Okay, but I was
previously in
just
the
talking about
argument.
the crack for a second, right? Just the rock of crack cocaine.
So again, I think the jury could infer based on their personal experience when looking at this photograph of this somewhat crumpled up white substance within it, it's not a rock, that they could infer that it would have been crushed by that action. Or even if they didn't
Without
think that.
any evidence about kind of the density of a rock of crack cocaine or, you know, I mean, you know, how crack is distributed. Does it come in one big rock and then you sort of chip off little pieces? And so that, you know, it's actually quite hard, but to chip it off, that creates some residue that's in the bag. Like there's no testimony about any of that to say, well, that's not how it works. You know, if it's crumbled, it's because it's actually quite powdery in substance. And I mean, there's just nothing in there to support that a conclusion that what is in the bag has altered as a product of him putting his foot on the bag.
Well, I think even leaving the cocaine aside, and I've sort of pointed out that it is somewhat crumpled, but also the bag itself,
But-
as has been noted.
But your colleague, just a moment ago, representing Mr. Wood said, well, when you see the bag come out, the bag is actually pretty tightly around the rocks of cocaine, right, around the crack. And so when it's shown in evidence, the bag has been expanded. What are we supposed to infer from that? As far as I mean, who tampered with the bag?
I think the bag coming out on the video, it comes out too quickly and it's too small to draw many conclusions about whether it's wrapped or it's not wrapped. I just don't think that is clearly shown in the video. My only point.
But that's all I mean, we have no observation of the bag beforehand, so all we have is this fleeting glimpse of something falling from his waistband. And then we have testimony that he puts his foot on it and nothing else. So even under a materially change or under a, a theory of altering means some physical change, what exactly is the physical change that the government thinks occurred here?
So I think the jury could infer that the change is either that the contents of the bag, the cocaine, was somehow crushed or crumbled in some way, or that the surface of the bag was wrinkled, scuffed, or again, crumbled in some way.
And you think
So-
they can infer that beyond a reasonable doubt?
I do, based on his actions, because his action, if you look at the video, it is a very deliberate motion, a stepping or stomping. And I would say that Detective Tran does say he stomped on it. It does appear that way from the video. Now, Detective Tran, I would also note, is blocking the view at one point. So, but he's right there. And if he says that he stomped on it, I mean, that is pretty good evidence that he did so. He says that his foot is actually on the product. And I would note that even though Mr. Wood has sort of suggested that there's no evidence what he did here, when you combine Detective Tran's testimony with Detective Love's testimony, what you have is you have him stepping on the product, stomping on the product, and dragging his foot back. And there is a part of the video, even though it is brief, that does seem to suggest that he is dragging his foot back. He's scraping it across the ground.
I don't think you can see his foot in the bag in the video,
You
right?
can't see the foot itself, but you do see his
And
leg
the
moving
testimony is that
backwards.
he's attempting to do it, so there's no actual testimony that his foot is in contact with the bag when he's, you say you can see his leg moving back. I mean, he's tackled almost as immediately as after the bag falls out onto the ground.
Well,
This is happening in
my-
seconds.
my opponent says that it was an attempt to drag his foot back, but that's not what Detective Love testified to, at least in a different part of his testimony. On page 159, he says that Mr. Wood put it on the ground, either on top or near the clear plastic, and then dragged his foot back. So I do think the testimony does indicate that he dragged his foot back, and that
Put it on the
is
ground either on top or near,
right. But then
right?
when you
So
combine
he's
that,
not, he's equivocal. He's not saying that it actually was on top, because if it's near, then it's not on top.
right, and if it was just Detective Love, maybe that would be more problematic, but you can combine his testimony with Detective Tran, who says that his foot is actually on the product and that he stomped on it.
Well, I don't think does he testify that he stomped? He said he stepped on it.
No, he says on page 75, he stomped on it.
So counsel, let's assume for the sake of your argument that there's been a stomp, the scuffing of the bag or a breaking up of crack rocks could be inferred. The question I want to ask you is kind of, so what? I get the argument that alteration, that the word alter just means to change. I wonder why it doesn't mean to, perhaps in a different formulation from what your opposing counsel said, to change in some meaningful way. This statutory section covers a lot of different kinds of evidence. And clearly, if I use the example from Judge Easterly of changing a date on a document, that is changed in a meaningful way, the nature of it. If I change if I add a new scuff mark to a scuffed up bag, or add scuff marks to a bag, or if I break up crack rocks, I mean, it's still crack. It's still got the weight as opposed to a ripped open bag where maybe we could infer there could be some missing. Where do we really draw the line at where alter gains some meaningful nature under this statutory section?
So I think the first thing I would say to answer that question is that I think what the council was concerned with here were attempts to basically fiddle or mess with evidence. And
Well-
really, in the legislative history, what the council indicates is that it's the third element, it's the mens rea that is doing most of the work in this statute. So I think the concern, that perhaps I'm hearing from the court is, so what? Why do we care? Why should we prosecute somebody if they just scuff up a bag, right? I think those types of de minimis concerns are addressed by the fact that the government still has to meet the third element, in which we have to, Mr. Wood would have had to intend to impair the object's integrity or its availability for use. But I think the reason why the second element is so important and should not be overread to require this significant change is because we want to discourage people from messing with evidence.
Okay, so if I have a bag of crack cocaine and the police are closing in on me and there is conveniently a vat of acid right next to me, and I decide I'm gonna put the cocaine in the vat of acid, and I have that intent, and I'm doing it because I don't want to get arrested and go to prison for possessing cocaine. But I have very bad aim. And instead of putting the bag in the vat of acid, I just drop it on the ground and I don't stomp on it. And the ground is very clean. Have I tampered with the evidence? You said that the mens rea is everything here.
Well, I would say it's the most important thing, but I would say that probably no, you have not tampered with the evidence.
I mean, what if a little bit of it breaks off as it falls down? Because apparently that's what the government wants me to infer, that crack cocaine can break if it falls on the ground.
I think, well, I'm talking about not just falling on the ground here, but also the action of stomping on it and scraping it. But I think if there were direct evidence that some of it had broken off, then yes, I think that would be a completed tamper. I think that would be a distinction.
That's a felony.
I would say so, yes. And I think the reason why that is because we take so seriously that we don't want people to fiddle with the evidence that they know are going to be used with them at trial. I would also note, just in response to these questions about the significant evidentiary value point and whether that should be required, that Webb essentially disagrees with that. And it says on page 510, a tampering with physical evidence conviction does not require the defendant to be successful in impairing the evidence's use.
It just seems like under this theory, the government then gets to charge tampering every single time a defendant discards evidence upon sight of the police. It's just sort of another a sentencing enhancement, as you were.
So
I toss a gun as I'm fleeing from the police and it goes into the bushes, and because I've concealed it in the bushes with the intent not to be, now I've got a tampering charge as well as a gun possession charge.
I mean, I suppose that's possible. I will say I haven't seen a case where we have charged tampering with physical evidence.
Well, we haven't decided this case yet to give you permission to do that.
That's right, of
So,
course. I'm just saying.
coming
that-
soon to a theater near you.
Right. I'm just saying that's of course possible, but I just haven't seen it. And I think that perhaps speaks to why that would be a harder situation.
Why would it be harder under the theory that the government is arguing right now? Which is, it doesn't really matter, you know.
I think abandoning evidence like that, although it could, I'm not sure it would be a concealment depending on the facts, right? Because somebody could just toss it into the bushes, but the police see it. So it's not really a concealment.
Well,
Obviously, if they toss it in the street, it's not a concealment because the police see it. So I think that's different than somebody making the deliberate decision. And I would push back on the sense that it's reflexive. I mean, if you look at the video, he looks as if to
You
measure
get
his
dirt
blood
on it, you
against
throw
that
the
ground.
gun and it falls into a puddle and it gets wet, right? And you have the intent to get rid of the gun, but you know, now it's a wet gun, you know, maybe that impairs the, you know, the fingerprinting of the gun. That's tampering now?
I think it could be, because that would be a pretty serious situation if you think about it. Like somebody would have taken a gun, a dangerous object that could be used as evidence at trial, and basically thrown it into a puddle to make it unusable or.
Well, I don't
somehow
intentionally
unworkable at
throw it
trial.
into the puddle. I mean, do I have to intentionally throw it into the puddle?
You would have
I'm just
to,
running and it's raining and it falls into a puddle.
you would have to do it with the intent to impair its integrity, as the statute says, or it's available for use in the official proceeding. So perhaps the defendant would have a good argument there at trial on the third element, right, as opposed to the second element. And I do think, again, these concerns, which are totally valid, about is this charge going to be overcharged? Is it going to reach de minimis conduct?
I mean,
I
quite
think-
frankly, it seems overcharging here.
Well, I wouldn't say so, because I do think that what Mr. Wood did here was wrong. Like, he knew that the drugs were going to be used against him at trial, and he made a deliberate effort to stomp on them and scrape them across the
Why was he
ground.
not trying to conceal them as opposed to actually tamper with them? Like, let me get my foot down real quick so they don't see this.
Well, you could perhaps make an argument that he was trying to conceal it, but I will say that that was not argued to the jury, and it wasn't in the jury instructions, so we're not.
And that
relying
just seemed
on-
odd to me that that wasn't the charge. But what concerns me a little more is I get as you've gone through this back and forth. It seems like there's definitely an attempted concealment, not here in this case, but definitionally under the law. We could have attempted concealment, we could have attempted mutilation, we could have attempted destruction. But it sounds like there is no attempt at alteration under your definition, like there is only completed alteration. Anytime someone even attempts to, in a way that we know they're trying to alter something, they stepped on it, whatever else, doesn't that just kind of swallow up?
Well, I could give perhaps an example of what would probably, I think, be attempted alteration. So what if Mr. Wood had dropped the bag, or the bag had fallen out, whatever, on the ground as he did here, and he stomps on it, he tries to stomp on it, but he misses? A jury could certainly infer that by, stomping on it, that intent, he stomped on it because he wanted to break it all up, right? He wanted to alter it, but he doesn't end up doing it because he misses. That, I think, would be an attempted alteration, right? So I do think there are scenarios even beyond this case where you could have an attempted alteration that wouldn't fit our definition, because he doesn't make physical contact with the bag. But here, I think it's important that he does make that contact, and there is testimony that he does scrape it across the ground. But I did want to also discuss, and I'm happy to discuss more about, one other point that I wanted to make just before I move. I would like to discuss attempted tampering, if I may. I just wanted to point to one more case, which is RFH. And I understand that that's a different regulation. I totally get it, but I want to point out that case before we move on, because that case was decided in 1976. This statute was passed in 1982. The council would be presumably aware of the fact this court has previously had a pretty broad interpretation of what is tampering.
I'm not sure I quite get it. I mean, the evidence in that case was the lock on the driver's door had been broken, the wires under the dashboard had been ripped out, the ignition was destroyed, and smoke was forming in the front seat under the dashboard.
Right, the facts of that case are different, of course, but
That seems like a lot of alteration.
in that case, there was, but the reasoning of the court when they're looking at what tamper means is whether it connotes wrongful or harmful interference. Wrongful interference. And I do think, just going back to my larger point here about what the jury can infer, if you're the jury and you're looking at a video, they can see it just like we all can see it. And you are seeing Mr. Wood step, stomp, drag his foot back on this bag of drugs, which he knows is going to be introduced against him at trial.
Right, but they're interpreting wrongful interference against all of those facts that I just listed. Like, I mean, I don't know. I don't find our FH terribly helpful to the government.
Well, I don't
Can
think
we,
it's.
can we talk about the lesser included?
Sure, yes, we could certainly talk about attempted tampering. So I would note that I think Mr. Wood has sort of painted this remanding in this case for this purpose as some sort of nefarious or unusual thing. This court has repeatedly done this, not just in Bailey, not just in Robinson. It has done it in Tan. It has done it in many other cases, White, any run of citing references of the Robinson case.
Can you delineate which one of those we were actually fixated on and which ones of those we were fixated on the issue and there was good argument on? Because as I read back and forth, I didn't see that apparent in all of them, and I was left a little confused by our case law.
Well, I don't think Robinson makes the point that the parties did not even raise it, and yet Robinson goes into great detail and analysis of the pros and cons of that. So I think even if the parties don't raise it, it wouldn't be accurate to say the judicial mind was not trained on this issue in Robinson. I mean, it was very trained on it. And I would just note a part of Robinson that I think is important, because I think a lot of the defense's argument as well, it's unfair, the government's being, sandbagging us, it's gamesmanship. It goes both ways. The defense bears as much responsibility for the strategy as the government. And Robinson makes that point on 112. It says, quote, in declining to request an instruction on a lesser included offense, the defendant may have preferred to make an all or nothing gamble on the trial's outcome. But where the defendant has lost that gamble and been found guilty of the greater offense, he is not aggrieved if his conviction is reduced to a true lesser included crime that is supported by the evidence and untainted by error.
But that's in the case where they had actually found, right, something while armed, right? I mean, they'd found the actual conduct, and it's the while armed piece that was infected by instructional error, right?
But
And
they
it's
would,
not this case.
but they would have necessarily found the same thing here. I mean, they found the greater, they found that he had in fact altered it. And there's been no dispute, I would note, that the jury was properly instructed. So the jury has essentially found that he altered the bag. How could they not have found that he came substantially close to altering the bag? And that is borne out by the video. So when we talk about being unjust under the circumstances, it would be unjust if an offense that is clearly captured on video, Mr. Wood would just be able to walk away from that. He makes the same gamble. And I would note that Mr. Wood says, well, the government isn't going to be held responsible. They make the same all or nothing decision. And if Mr. Wood was acquitted, if he had won his gamble, we would not be able to appeal that conviction. So it's not true that the government is somehow getting its cake and eating it too. They are making the same judgment that we are making. And it is not correct under this court's case law that there is some sort of systemic prejudice. Bailey does not stand for that. It is whether it is just in the circumstances. It is a case-specific inquiry. And here, given the fact that the offense is captured on video, the jury is properly instructed, they would have necessarily found that he altered it. But even if this court decides the evidence was insufficient that he actually altered it, I mean, I don't think you can look at that video and not conclude that at the least Mr. Wood attempted to alter it. And so for that reasons, at the very least, we would ask that this court remand and enter a conviction for attempted tampering. And if there are no further questions, we would ask that this court affirm.
Thank you. Thank you for Mr. Burney.
A few brief points, Your Honors. A lot of the discussion of the evidence here was that it was, it all happened so fast. It's too hard to see what happened. The officers weren't asked and didn't say much about exactly what happened with this step. Let's remember, it was the government's burden to prove beyond a reasonable doubt that Mr. Woods did something that in fact caused, even under the government's definition, at least some physical change to the bag or its contents. And it didn't bring that evidence to court. I'd remind the court that in Rivas, this court said, slight evidence is not enough. A modicum of evidence is not enough. It has to be evidence sufficient to draw an inference beyond a reasonable doubt. And here what we have barely qualifies as slight or a modicum of evidence. You have Officer Tran saying Detective Tran saying 4 times that Mr. Woods stepped on the object, only once that he stomped on it. You can look at the video. It doesn't look like a stomp to me. If anything, that's very slight evidence of a forceful step. Detective Tran never described a dragging motion while the foot was on the object. Detective Love is the only one who described a dragging motion, and he could not say that the foot was on the object at the time. The government highlighted his testimony where he explicitly says he dragged his foot backward, not the bag backward. So cobbling this together and trying to bootstrap the testimony of those 2 officers and a video that shows nothing into proof beyond a reasonable doubt that an action was taken that must have physically altered this bag or its contents is just the definition of the kind of speculation that Rivas prohibits. It is an additional speculation to presume that the bag wasn't already dirty or that the drugs weren't, or the suspected drugs weren't already crumbled before that step, even if the step would have had those effects. So it's speculation upon speculation. And although this court doesn't need to go there because that alone, that insufficiency is basis to reverse the conviction here, it just highlights how absurd the government's interpretation of this offense is, of the term alteration, to suggest that an individual can be guilty of a 3-year felony for getting the outside of a plastic bag dirty in a way that has no impact on the case before it. There has to be some de minimis amount of alteration. And this, which has no consequence for the evidentiary availability or value, certainly is it. Courts across the country have declined to read the words concealed and removes in similar tampering statutes to apply to acts that have no impact on an object's ability or quality as evidence. Acts like tossing a gun while running away, acts like trying and failing to swallow drugs, as the Florida court in AF, which the government cited, found was not sufficient evidence of a completed tampering offense. So too should this court hold that alters also does not apply to such de minimis evidence. It would be in good company in so holding, because we've provided the case from the Alaska court in Anderson, which said that is an unusually sort of inexplicably harsh result that we don't think the legislature intended. Here we have clear indications that the legislature was not trying to get at attempts to tamper because it knew how to use that language. It used it in the same legislation in another part of the statute. It chose not to use it here in the attempt in the tampering statute, and alters has to be read consistent with the legislature's purpose here. Webb is not contrary to that. Its explanation that a tampering with physical evidence conviction doesn't require the defense to be successful in impairing the evidence use was talking about being successful in impairing the use of the substance of the evidence. It was not presented with the question that the court has here of whether a failed attempt to impair the target object constitutes tampering, because there the attempt was successful. The Instagram post was deleted. It was altered. And Webb was simply saying where there's another copy, right? That doesn't impact the fact that destroying the first copy, the target object, constitutes tampering. To the extent Webb could be perceived as relying on Timberlake to make some broader holding, that's a misreading of Timberlake, because Timberlake was an attempted tampering conviction, not a completed tampering conviction for attempting to swallow drugs. Finally, I mean, I think the government's argument here, well, he did something wrong, right? That's exactly the gamble that they chose to make in the court below. He did something wrong. Here's a felony completed tampering instruction and nothing else. Let's see if the jury will be persuaded of that. The defense, seeing that strategy, was not under an obligation to suggest to the government other crimes that could be charged against him, chose the best strategy in response to the prosecution that it was facing. And that strategy was to count on the jury to hold the government to its burden of proof. Unfortunately, the jury didn't do that. We are asking this court to do so, and for the government to be bound by the consequences of its strategic choice, just the same as we were. This is not the type of relief that's being asked here, is not at all routine. It is so out of the ordinary that the court needed a whole round of post-argument supplementary briefing in Robinson to do it. And the circumstances of this case are distinct from Robinson. Even if it was just to offer that kind of relief in Robinson, it is not just to do so here, and it should not be expanded to this type of case, lest the government be incentivized to over-prosecute more cases where their evidence is weak across the board, weak on completed offenses, and they try to shoot them in with the jury at great cost to the defense. So for all of those reasons, we would ask this court to vacate completed tampering conviction and remand with instructions to enter a judgment of acquittal.
Thank you, counsel. Thanks to you both. The case will be submitted. Second case on our calendar today is 23 CV 826, Client Earth et al. Versus Washington Gas Light Company. Counsel, whenever you're ready.
Morning, and may it please the court, I'm Renee Wickland, and I'm here on behalf of the plaintiff appellants, Client Earth USA, the U.S. Public Interest Research Group, and Environment America Research and Policy. And I'd like to reserve 2 to 3 minutes of my argument time for rebuttal with the court's indulgence. So the DC Consumer Protection Procedures Act, by its literal terms, does not preclude a public interest organization from suing a defendant that is subject to regulation by the Public Services Commission. The question this case presents.
And when you say that, what can you walk us through that?
Absolutely. So the language that we're concerned about is in the CPPA 3903 C2.
Well,
And
is that where we start? I mean, if you're talking about the statute by its terms
Mhm.
in 2020, which I think would be the operative statute at the
Mhm.
time, right? We're looking at the statute as it existed at the time of the pled conduct.
correct.
Okay, so if we're looking at the statute, I would go right to the private right of action under 3905 K1, right?
Certainly, in this case, that private right of action would be 3905 K1D,
Okay,
which establishes what is called the Private Attorney General Public Interest Organization standing. And that was put into place, as the court knows, in 2012, 3
Right.
years after what we've kind of been arguing about in this case, which is the court's decision in Gomez.
right,
versus
but I thought you
Independent Management.
said that the statute as it exists. Well, I can't remember exactly what your initial language was, your
That-
initial opening statement.
Was that the statute, by its terms, so
By its terms, so
Yes.
by its terms, you represent Client Earth and other public interest organizations. And so you go to 3905 K1, which confers upon you a private right of action,
specifically K1D,
K1D.
that is correct.
And the rest of K
Well,
discusses the private right of action, right?
yes,
And it
although-
says any claim can be brought in Superior Court, and here are the remedies. And it doesn't say anything about you can't sue anyone under the public service, who's regulated by the Public Service Commission.
You're absolutely right
Okay,
about that.
so that's K1.
So that's K1D.
Okay.
Yes,
So the argument is that we're supposed to be looking somewhere else.
the argument is that in the Gomez decision in 2009,
Right,
this,
which was interpreting which form of the statute?
it was interpreting simply K1, and I
No,
say,
sorry, the year. I believe it was
It-
interpreting the 2001 version of the
The
statute.
2001 version of the statute, yes, following the 2000 amendments.
Okay,
And what was being interpreted there in that version of the statute was a provision in 3903
Right.
C2.
and 3903 is the powers of the Consumer Protection Agency.
Correct. And that is so important in this
So why
case.
are we looking at 3903 to determine what the private right of action permits?
Because the the Superior Court found that because this court determined in 2009 that if a department couldn't bring the private right of action in Superior Court, neither could an individual aggrieved plaintiff.
Right, and I find that so interesting, right? Because 3903C2 says the department may not apply the provision of 3905 to persons subject to the regulation of the Public Service Commission. The department is a defined term.
Yes.
Yeah.
At that time, it was the DCRA.
Yeah,
now the
it's all, I mean, I
PLCP.
think it's always been a defined term. Did Gomez mention the definition of department?
Gomez did mention that the department meant the DCRA. Yes,
It did. Okay.
I do believe so. Yes, but also found that in the 2000 amendments, which had originally linked individual jurisdiction to what was within the department's jurisdiction, that was actually removed from the 2000 amendments. And yet the court found that, and we actually don't dispute that Gomez remains good law. I do believe that Your Honor found that in the Sizer v. Lopez Velasquez decision, that Gomez has not been overturned.
Well, I don't think there was any sort of argument in Sizer that the statute after the 2012 or 2018 amendments changed Gomez. The argument in Sizer was, can we look at the amendments now and evaluate and impose them retroactively?
Exactly.
So the issue about whether Gomez was good law was not before the court in Sizer.
Well, and we don't challenge whether Gomez is good law because we think that actually what the Superior Court found does not follow from Gomez itself in this case. We think that the Superior Court created a new rule when it said the department in this case actually means a private attorney general, means a public interest organization. That's a brand new rule, we feel, that did not follow.
I'm sorry, I
from
didn't
Gomez.
follow what you said. The council said that the department,
The Superior Court
right?
said department, as it is used in 3903 C2, should be read, because the department can't bring an action, that should be read to say that a K1D private attorney general action cannot be brought. That was the holding of the Superior Court. And that is the holding that we think was incorrect. We don't think it followed from the logic of Gomez, and we think it actually contravenes subsequent language by the.
Why
DC
is that
Council.
right? I mean, if you have a private right of action under K1 and you say in Gomez, I believe without citing the definition of the department, but you can correct me if I'm wrong. Department actually means not just the department, but any individual plaintiff.
Oh, I see. Pardon me, I misunderstood the question. Yes, you are correct, Your Honor.
I don't believe Gomez looked at the definitional section when it decided department. But then certainly it doesn't have the definitional provision of public interest organization, which
Correct.
is enacted much later.
Exactly. That
So-
would be 3901, A14.
But if you're saying Gomez is still good law because it's okay to say department, although statutorily defined as department, actually doesn't mean what it's statutorily defined to mean. It also means individual plaintiffs are bound by this restriction on suits under their private right of action under K. Why then would we say, okay, individual plaintiffs can't do this, but nonprofits and public interest organizations can? That's a hard pill to swallow.
Well, to begin, I'm not saying that Gomez is good law because we think it's good law, or we think we support its reasoning, or we think it applies here. I'm saying it's good law because, to my knowledge, this this court has not overturned Gomez. So
We've
in
not
that
been
sense,
asked to.
this is
Have
fine.
we? I mean,
We-
in
we-
Sizer,
we
we
have
were
not-
asked to apply new statutory amendments retroactively,
Mhm.
and we declined to do so,
And
right?
in
In
Petrangelo.
Petrangelo, we didn't cite Gomez.
Mhm.
We seemed to follow the same logic of Gomez, but no one was making an argument that, look, the statute has changed enough that the Gomez logic doesn't hold up anymore. That argument was not before the court, nor was it before the court in our other
Falcone.
in Falcone Sachs.
Mhm.
That just was not, in none of those cases have we been asked to look at Gomez and say, look, maybe this was right when it was decided, but the legislative ship has gone in a different direction. And it shows that now we have a very robust private right of action that is not limited, that is not coextensive with the limitations on the department.
I will make the argument now that Gomez cannot be considered good law for whatever reason when it comes to a public interest organization action as it was created 3 years after Gomez.
Do you think a public interest organization is permitted to sue clergymen and the other entities that are that are not proper objects of suit for the department?
Yeah, I do think so, Your Honor. And I think that the BC Council signaled that they are.
How did it do that?
Well, when we look at the At-Risk Tenants' Rights Clarifying Act that came to actually amend the provision that was at issue in Gomez, that happened in 2018. It was actually preceded in 2017 by Resolution 2233, which was an emergency resolution. And that resolution addressed a concern that, quote, a District of Columbia court might question whether the AG, the Attorney General, has authority to bring a CPPA action in the landlord-tenant arena. Again, this was before the amendments relating to landlord-tenant relations. And here's what the council wrote in that emergency resolution. This concern is due to the language in the CPPA that prevents the Department of Consumer and Regulatory Affairs from applying the CPPA to landlord-tenant relations. Even though this language by its express terms applies only to the DCRA, a court might nevertheless wrongly interpret that provision to foreclose an enforcement action brought by the Attorney General under the CPPA. Now, this is a private Attorney General action. We know that because in the Alexander report, the committee report underlying the creation of K1D, the legislature says, Bill 19-581 clarifies that public interest organizations may act as private attorneys general for the public interest. So this was not set up as a private DCRA action. It was set up as a private attorney general action as an interplay between the attorney general and sort of an expansion of what the attorney general can do, private attorney general actions. And I think that that's borne out also through provision 3905K7, because that provision provides that public interest plaintiffs must give notice to the attorney general, not to the department, to the attorney general when they bring a CPPA claim. And if the attorney general chooses to bring a claim on the same subject matter or the same area, then that stays the action of the private attorney general. So these actions work in tandem with attorney general actions. And we have the council saying in 2017, you would be misinterpreting 3903 if you were to say the department not being able to bring an action precludes the attorney general from not being able to bring an action. And so we do think that that is relevant and signals the council's intent that the logic underlying Gomez, whatever we want to say about it, would not apply to a K1D action as that was created statutorily after the
Is
Gomez
it that
decision.
simple though? Because the K1D action, though it changed the requirements for standing for public interest organizations, still does it not have the language about bringing an action where a consumer would be able to bring an action? Does it not? I mean, it is true that the public interest organization does not have to show injury in fact to itself. So that's the big dramatic change. But the reasoning in Gomez was that individual consumers would not be able to bring suit where the department could not do so. And since the standing of the public interest organizations under K1D is linked to the standing of consumers, why wouldn't the contrary conclusion apply? I mean, I follow your argument that a public interest organization is acting as a private attorney general. Let's see what the attorney general could do. I get the logic of it, but why wouldn't it be just as true that since there is this linkage between what consumers can bring and what a public interest organization can bring, that the same limitation that Gomez said applies continues to apply?
There's a link, but not a limitation, Your Honor. A public interest organization can bring any action that an individual consumer could bring, but nowhere in the statute of the case law does it say that they can bring only what an individual consumer could bring. And that's consistent with the way K1 itself is set up. If you look, K1 3905 A through E, and I misspoke just a second ago, I meant this is consistent with the way 3905 is set up. Provisions A through E and H actually have to deal with bringing a complaint to the department itself. That's what a consumer does. That's what an individual consumer does. But when an individual consumer standing is under K1A, but when the legislature created K1D, it sort of took us out of that schema. Sort of what is suggested in Gomez is if the individual consumer couldn't bring this to the department because the department lacks jurisdiction, then why can the individual consumer bring it to the court? But with K1D, we're operating in a wholly different schema. There's no provision for public interest plaintiffs to come to the department in the first instance.
So how
That's
do you
the
address
difference.
Hormel then?
Yeah, I'm sorry.
So how do you address Hormel then and the limitations we put in there?
Which limitations in the Hormel decision, please, Your Honor?
Where we discussed how the organization would still need the same standing an individual would have.
I think that Hormel created the three-part test to make sure that the organization had sufficient interest in the action itself. But I don't think that it created a limitation that specifically said only what the individual consumer can bring. That wouldn't make sense because, as Judge Thompson just recognized, individual consumers can only bring under Grayson what has injured them, and we're not limited in that sense. So it's clearly not a wholesale limitation between the link of the public interest organization action to the individual action.
I'm sorry, can I just take you back to your understanding of 3905? So I get that 3905, the beginning of it, A through J, I think really have to do with, I mean, because, after E, it's sort of like,
There's
well,
some
what
other stuff
happens-
in there.
What
Yes.
happens after, right? And where does it go if you want to contest what happens before the department? So I get that that's all about bringing a complaint to the department, and that is of a piece with the original impetus for the statute in 1976 to create this robust consumer advocacy government organization or government entity agency that will advocate for consumers, right? Because the previous entity was not doing its job. And so they thought, okay, we'll just remake this agency. But at the last minute, they add this private right of action in 1976. There's not really any legislative history about it. And yet since that time, this private right of action seems to have blossomed, right? And so now it's an individual can sue, and these organizations on behalf of individuals can sue, right, as private attorney generals. But you were saying under K1A, that the consumer, it sounded like you were saying that K1A sends the consumer back to the department. Whereas I understand K1 Two, to say the consumer goes to Superior Court.
You're absolutely right. The consumer can bring something to the department, but the
Right.
consumer also has a right of action in the court.
Right, that's under K, right? I mean,
And I think that the reason that I refer to A through E and H is actually a question we may not need to decide here. As your honor knows, before 2000, the private right of action was explicitly linked to department jurisdiction.
right,
That was taken out in 2000. And I think the idea that the individual consumer goes first to the department is sort of a vestige of that earlier
but
thinking.
they don't have to
but
go first to.
No, they don't have
There's
to. They
nothing
come
in the
directly into
statute
court.
about exhaustion by
That is
going to
correct.
the department.
Yes.
You can decide as a consumer, I want to go to court and sue. I mean, it's
Yes.
hard for people to go to court and sue. So going to the department might be an easier course for a consumer. But you can go to court and sue and you don't
Yes, you
have to
can.
exhaust anything, right?
Yes.
Okay, so I guess I'm still, this leads me to the question that I've now forgotten, but you were making a point. What was your point?
I was making a point that I believe underlying the Gomez decision was an idea that individuals
You're saying Gomez was just conceiving of individuals
as coextensive
as
jurisdiction
going
with
back
the
to the
department.
department, but
Correct.
that's not how K is written,
No, and it's certainly not how K1D is written.
right? Okay,
So I think that we are in agreement on this point. I think that there is a lot that is in Gomez that we don't even need to reach here. The Superior Court relied on Gomez, but we're talking about an entirely different statutory schema at this point because of most prominently the 2012 amendments in reaction to the Grayson decision. But we've seen both through the decisions of this court in ALDF and in the Center for Inquiry case, a consistent expansion of what the CPPA covers and who can bring the cases. And one argument that we face all the time here is that we can't do this because it's opening a floodgate of litigation. And as your honors know, having sat on many of those decisions, it was often promised in those cases as well. And that is something that defense counsel argues here, but it's just not realistic, I don't think. The issue that we have here, and I think that the defense counsel recognizes this. If this action cannot be brought in the Superior Court, it's not brought. We need to be pragmatic about that. Before the Superior Court, defense counsel said.
and by this action, you mean an actual CPPA action?
No,
Right, because their argument is, hey, maybe you can't bring CPPA claims, but you can raise the same sorts of concerns before the Public Service Commission.
But this again comes down to who the you is. Title 34 before the Public Services Commission has no private attorney general provision. It has provisions for customers to bring their complaints. And the legislature has already realized that.
Well, I thought your first response was, we want to bring a CPPA action.
Well, we do because we think we have a right to bring a CPPA action. But what the defense counsel has argued is no, everyone go over and talk to the Public Services Commission. And that's just not the way the statutes are designed to interact with one another.
Well, can you speak to that? I mean, where do you see what's the basis, or I mean, I guess maybe I should ask them, what's the basis for their argument that you have to go to the Public Service Commission? Why can't you go both places? It seems like we have a pretty robust, I'll use that word again, consumer protection structure in the District of Columbia where consumers can go lots of places.
Consumers can go lots of places. Consumers often lack the resources, the means to do so, and that's why the legislature empowered public interest organizations to do so. I don't see that public interest organizations have any mechanism for filing something like this before the Public Services Commission. I would, however, agree that even if they could, it wouldn't preclude this.
Right. I mean, what's the obligation that they have to go there? But I don't see any case law on sort of preemption or, right? Like, that's what they would have to argue, is to say, look, the Public Service Commission occupies the field.
In
And-
fact, they did argue exhaustion of remedies before the Superior Court, and I see
But
absolutely no
exhaustion
basis
is
for that.
different. Exhaustion means you go there first and then you come here.
Right.
But that's not what I understand them to be arguing. I thought that they were arguing sort of the Public Service Commission occupies the field, but they haven't supported that with any.
Well, the argument
law.
is Gomez. Gomez said that the restrictions on the department and who it can proceed against are the same restrictions that apply to consumers. I mean, you have to, the argument is a linked argument, and if public interest organizations have the same standing as consumers, then they are limited by that same a restriction on who can be sued. That's the argument.
I'm actually very glad that you brought this point up, because as we say in our papers, Gomez was indeed about who can sue. But defense says, no, it was about who can be sued, and there is effectively an altogether bar on anyone mentioned in 3903. They're all exempt from CPPA cases. And they actually don't even get that from the Gomez language. They take it from a snippet of language in the Petrangelo decision.
Well, they can get it from Gomez too, because Gomez actually quotes the language about the restriction on what is the list? Clergymen, lawyers, Christian Science practitioners.
Of an individual
right.
aggrieved plaintiff, because the question was, if it's if they're bringing it, are they the same as if the department is bringing it? But 10 times in their brief, they quote this snippet from Petrangelo. The CPPA specifically excludes the professional services of lawyers from its purview. And from that, they say, see, it's not about who's doing the suing. It's about who's being sued. And I really think that that is a complete reversal of what's going on and contravenes what the council was saying in 2017, which is, no, it really is about who's doing the suing. I think that that language appears in Petrangelo because there was no reason to talk about the identity of the plaintiff.
Well, I
It's an
wonder if
individual
that's right. And that's part of the reason why I asked you whether you think that your organization or the organization you represent could sue Christian Science practitioners and clergymen and lawyers, because it seems to me it's all or nothing.
I think if they were engaging in conduct that violated the CPPA on such a widespread basis as to draw the ire of a nonprofit on a shoestring budget, yes, they could.
Then why should we think the council intended that? I mean, Gomez seems to say, look, when the council withdrew the link between what consumers could do in the department, it's because the department had budget issues and the department was not going to be taking the lead. So we're just going to take that out. And it's as if no one thought any further than that to figure out whether they needed somehow to address these restrictions in some other way. I mean, I find that kind of persuasive, so I'm not really sure the council intended this liberalization of who could be sued. And I will say that I guess the statute governing the commission, maybe the commission's own regulations don't have anything that addresses standing of public interest organizations or ability to sue, but there certainly are cases where the Public Service Commission has entertained claims about deceptive, false, misleading advertising, and its statute 34402 says it shall inquire into matters of like that.
Absolutely, but when we look at the complaint procedures, they're for customers. So I think that, yes, it shall inquire, and it would be great if the Public Services Commission were inquiring into statements that you're going to reach carbon neutrality through the use of methane gases, but it's not happening. And that's why we need the teeth of the CPPA, so we can have a judicial imprimatur to say, stop making those misrepresentations.
Well,
To your knowledge,
Yeah.
has anyone asked the commission to look into that?
We have not entered discovery yet, so we're limited in what we could figure out. We don't see that the commission has looked into it.
Well, counsel, if I can jump in, if the commission has been delegated some of that authority, I mean, it caught me that it wasn't in the briefing, but DC Code 34-1671.08, Consumer Protections, specifically asked the commission to adopt regulations and issue orders looking at the natural gas supply regarding marketing, solicitation, sale, and provision of retail natural gas. why should we not read this, which admittedly came about in 2005, and perhaps because it's newer, as a direct delegation to the commission?
I think a couple of things. Number one, as we've realized, there is no complete occupation of the field. I think that number two, it's clear when you read the entirety of Title 34 that what it's concerned about there is things like misrepresenting the cost of the natural gas or whatever the product is, misbilling, shutting off water and, shutting off your gas line without proper notice and those types of things. Widespread consumer deception about the environmental impact of the product is not considered in there as far as we can tell. And again, these plaintiffs are empowered to be the ones who say you can't deceive the public on such a widespread basis, but Title 34 doesn't give them any way to show up and compel the Public Services Commission to look into that. And that's why I say if the action is not brought in Superior Court, we're unlikely to see it rise anywhere at all. And with that, I'll sit down for now and reserve a few minutes for further questions from the panel.
Thank you, counsel. We'll give you a little bit of time for rebuttal.
Thank you.
May it please the court. This case is not about who has standing to bring a CPPA claim. It's about whether a CPPA claim exists in the first place. And the answer to that question is no. Plaintiffs state in their reply that they are not asking this court to overrule Gomez and its progeny, regardless of what they are saying today.
They don't need to, right? I mean, I think their point is the statute that Gomez was interpreting was a 2001 statute, and the statute that we're interpreting is the 2020 statute. And the statute is just different. Say what you will about Gomez. And I have some thoughts about the statutory interpretation in Gomez and would like to explore those with you. But their argument is Gomez just doesn't apply to this situation given the change in the statutory landscape. So let's look at the statutory landscape right now, right? Like, do you agree that for a private right of action, you start at 3905 K1?
I do, Your Honor.
Right? Okay. And 3905 K1D says that public interest organizations can sue. And 3905 K2 says you can go to Superior Court. And I don't see anything in 3905 K that says public interest organizations going to Superior Court to bring their CPPA claims under 3904 cannot sue these people.
That is correct.
That's just not there, right?
But-
So then you have to go, your argument is, well, we go to 3903.
Well, actually, Your Honor,
No?
I don't go there first.
Okay, all right, where do we go
First, I
next?
Is I actually stay in.
But it seems pretty powerful that 3905 has no limitations on who can be sued, and particularly does not say Washington Gas or any entity regulated by the Public Service Commission cannot be sued. But it's just not there. So
But
it
Your Honor-
seemingly is permissive, like you can sue anyone. I mean, any merchant, right? You
Well-
have to sue a merchant. And I don't hear you saying that Washington Gas is not a merchant under 3901, are you?
Your Honor, just to step back with your first
No,
question.
can I just get a question? Are you arguing that Washington Gas is not a merchant under 3901?
We are not arguing that here, Your
Okay,
Honor.
great, thanks.
What we are, just to back up, before we leave K1DI,
Yeah,
it is not without limitation, Your Honor. And in fact, in Hormel, this court looked at this section in detail and actually noted that this statute creates a three-part test. You described this as that a public interest organization has to check 3 boxes. And the second box it has to check is that an individual could bring this claim. So before
I
we,
thought we weren't talking about standing. I thought we were talking about who could be sued.
Your Honor, we are.
Isn't
talking-
Hormel a standing case?
Hormel is a standing case, Your Honor,
Okay.
but the point of that statutory language is what it tells us is that the council was not trying to remove any link or any association for public interest organizations to individuals. So for example, when you look at.
Right, but if
K-
you have a statute, I mean, let's put Gomez to the side for the second and come to the 2020 statute. And the 2020 statute is what a consumer or a public interest organization or a nonprofit, what they can do and who they can sue. Right? And they can sue for unfair trade practices defined in 3904. They can go after merchants defined in 3901, and there is no limitation in K, 3905K, as to who they can sue. Am I right?
But Your Honor, by that same logic, there's also not any limitation for individuals or nonprofits. And so
Correct.
that would.
Right. No, I'm just taking the statute as it reads because I've been told we're supposed to start with the text.
Well, we are also still reading the text in the context of the existing case law.
Okay,
in this-
you want to go to Gomez and that's fine, but I just want to make sure if we're looking at the text doesn't have any limitation on who can be sued under K.
Your Honor, no, not on the
No.
face of the text.
And even if you take me to 3905K1D I, which says if a consumer can do it, still, the consumer gets everything under K and there's no limitation under K on who a consumer can sue.
Only if.
Only if you go to 3903 under Gomez.
Yes, but also if we ignore Gomez, Falcone Sachs, Sizer, and Petrangelo, and Your
Okay,
Honor.
can we pick off those, because I think it comes down to Gomez and we can talk about Gomez, but Petrangelo doesn't address the question that we're presented here, which is what does the statute look like right now, right?
So
That just wasn't argued. The judicial mind wasn't focused on that.
I am not
Can you
going
agree?
to, I'm not going to dispute what the judicial mind was focused on or not. All I can go from is what is in the holding of that case.
Right, but there was
And that-
no argument to the court that the statute had materially changed since 2001.
No, that had not been raised, Your Honor, but I'd
Okay.
also like to note.
That is raised here.
But we are skipping over the 2018 amendment in this discussion.
Well, the 2018 amendment is incorporated into the 2020 statute,
Yes,
right?
and what's important about the 2018 amendment, because what Your Honor seems to be saying is we are going to take Gomez and we're going to take that body of law about what individuals can do, and we are going to completely set all of that aside on those
Well,
limitations.
no, I haven't even gotten to Gomez yet. I'm just trying to get some baseline understanding about what the text of the statute says as it stood in 2020, which is the operative statute.
Well, Your Honor.
And so
then
I
would-
take it you want to take me to 3905 K6.
Yes, Your Honor.
Okay,
And the reason I want to go to case 6 is because it demonstrates that when we look at what the council was doing, or what you want to look at the statutory text. And yes, there's no limitation in K1A, B, C, D. What we see is the council expressly moved landlord-tenant relations into the scope of the CPPA.
well,
And there would have been no reason to do that after the 2012 amendments if truly this text was unlimited. Right? Like if you're saying 39-303.
could just be, I mean, look, that's a superfluity argument. Like, why do you need to do that? But there had been case law, Sizer, saying we don't understand the statute to allow people to sue landlords, and they're saying, no, it is. But I mean, by your logic, if the addition of 6 is just saying, oh, well, this is what's permitted, then by implication, nothing else is, right? Like, so that can't be true.
What I'm-
That's giving 6 way too much power.
What I'm saying is they looked at the category of exemptions and they saw that this exemption needed to be
But
eliminated.
that goes to say, so now let's go to 3903, right? Because you're calling them a category of exemptions. But 3903, you'll agree with me, is about the powers of the Consumer Protection Agency. That's what the title is. And that's what A says, the department in its discretion may do these things, right? And then it says the department shall do some other things in B, and then in C, it says the department may not. And in C2, it says you can't, the department can't apply 3905 to these categories of defendants.
Yes, Your Honor.
Okay, right. Gomez looked at that and said that applies to K1. Did Gomez look at the definition of department when it did its statutory interpretation?
I'm not aware that they did, Your Honor.
Yeah, I don't think they did, right? Seems incomplete. So there also doesn't seem to be an appreciation in Gomez of sort of the statutory structure, right? That really we have this private right of action that is separate from what the department can do, but certainly what the amendments in 2012 show is there is, and 2018 shows that there is a distinct private right of action, one where you have these other entities, nonprofits and public interest organizations can bring suits, and their ability to bring suits is not coextensive with what the department can bring, right?
Well, Your
I mean,
Honor,
that's
disagree.
K6 makes that very clear.
But Your Honor, I disagree in the sense that you're saying they changed something in 2012 to make public interest organizations wholly different from individuals. And that's just not what the text in this private right of action does. The second box that's articulated in Hormel. And
Well,
that's
I'm not sure that they
articulated in
made
statute.
public interest organizations and nonprofits different from individuals so much as they said all of these entities are not the same as the department.
Well, there's no indication that they addressed that, Your Honor, and
Don't you think in 2018, by virtue of saying, hey, you affirmatively can sue landlords, they are saying your ability to sue people is just not coextensive with what the department can do?
no, Your Honor. What I think they're saying there is,
Well, on its face, it is, right? I mean, at least in that narrow respect, it is not coextensive. But it would seem to suggest we don't understand K1 to be bound by C2. But take the narrow, right? I mean, you have to agree that public interest organizations and consumers can now sue landlords under the CPPA.
yes,
And that is not true under C2. And to the extent that Gomez said, hey, we understand that the ability for individuals to sue is coextensive with the department can do, that is not true anymore. And that assumption is not true anymore.
Your Honor, I don't follow that logic. The 2018 amendment looked at landlord tenant case law and decided to bring that what was based on 3903C, all of those decisions, and the fact that there was an exemption that was tied as late as 2018 to the department in 3903C and said, we are moving that into the realm of things that can be covered by the CPPA. If the council had intended to either in 2012 eliminate all of the limitations on the department that are coextensive with individuals,
But
it would
maybe
not
it meant
needed
that
to
the
do
council
that.
didn't perceive the limitations on the department in C2 to be limitations on public interest organizations or consumers at all.
Then it wouldn't have needed to make the 2018 amendment, Your Honor. It would have
Why
been
not?
unnecessary, because if there were no limitations as of 2012.
I mean, maybe it's not the best way of amending the statute, but certainly it indicates, it undermines the foundational assumption of Gomez that the scope of a private right of action is coextensive with the department's right of action.
Your Honor, I'm having trouble following that logic because it doesn't say when they added K6, it doesn't say only individuals. It doesn't untether the link between the department and the individuals that exist in the case law. It applies to all those categories in K1.
Right.
And so there's no indication whatsoever that the council intended to upset the existing judicial landscape by
I mean, your
making
point
that
was
change.
gonna be if those other limitations didn't apply, there would have been no need for
There
this
would have been
specific
absolutely no need.
exemption for landlord-tenant relations.
Absolutely, Your Honor, because to the extent that putting all of the other exemptions to the side because they brought in an express right to sue landlord tenants is having that
But
amendment
what
do a
about
lot
the
of work.
legislative history that was quoted to us that says, hey, there's this understanding that C2 applies to K1 and C2 only applies to the DCRA, right? Like the council said that, and that is, it's a foundational premise that the council then seems to be acting on to say, "No, they don't, it doesn't apply." And, you know, look, we're not necessarily lawyers over here at the council, and we're just going to say, we see all of, we haven't seen any public service commission cases, but we've seen a lot of landlord tenant cases, and we don't think that they should be off limits for a private right of action. So we'll just say that explicitly.
But Your
And
Honor,
that's what they did.
and they certainly could do that for public service by persons subject to
Well, they might,
regulation.
if we,
And they
if
might,
we resolve this case in your favor, but I'm not sure that we are bound to under Gomez, because it seems like they've already signaled that to us. They've changed the statute, and Gomez itself, by failing to acknowledge that department means department when it's interpreting C2. And, you know, now we have a new statute that says public interest organization means public interest organization and does not fall under the definition of department. I'm not sure why we would be bound by Gomez
because
interpreting a 2001 statute.
starting with 2018, Your Honor, that language was dealing with the Attorney General. And I think actually the analysis that was done in Sizer is actually really instructive here.
Yes,
Because-
thank you. I'm
let's
glad that
talk
that was
Sizer.
helpful to you,
Okay,
because Sizer, I don't see has anything to do with this case, because Sizer is, the question in Sizer is whether new law should be applied retroactively. And
So
to the
that was-
extent that there is anything in Sizer that indicates that we are weighing in on what the old law meant, that's
Well,
not what we were doing.
keep in mind that.
I mean,
the-
old law under Gomez. That wasn't, we weren't asked to say, to examine the new statutes and say, is Gomez good law? That was
No, Your Honor.
not
but you-
before this judicial
But
mind.
you were asked to weigh in on whether Falcone Sachs was still good law. So on appeal, Ms. Sizer, and this is at page,
Right, but
304.
Falcone, Sachs and we just weren't being asked to look at the new statute. I can't say it enough.
okay.
We
Your-
weren't being asked to look at Gomez and say, in light of the 2012 and 2018 amendments, Gomez is no longer good law. That wasn't the question in either of those cases.
Okay, Your
That
Honor.
is the question here.
Your Honor, backing up, the question here is whether or not there's an exemption for the entities from the CPPA under 3903C. And what we know from the
I thought the question was, does Gomez control in light of the fact that we are applying the CPPA as it exists in 2020? And that incorporates amendments to the CPPA in 2012 and 2018.
Yes, and those amendments, the analysis that Gomez did, where it looked to these amendments that had happened in 2000, which, as you said, made a change where they eliminated the express link to individual rights to these limitations. And they said the silence of the council, meaning not speaking to the actual issue around here, was not enough to make such a consequential change that the CPPA in its own scope would now cover all of the exemptions, including clergymen, including any person subject to regulation by the commission, including an action of a government agency in the exemption. So by the logic that today, the 2012, 2018 amendments mean that all of those entities, because remember, your argument that K1D is different because it's silent, well, it doesn't say the department, neither do the individual or the nonprofit. And so to the extent all of those entities now are unfettered by 3903C, that means that they would have a CPPA claim seeking injunctive relief and civil penalties and treble damages against an action of a government agency, in addition to a person subject to regulation by the
Yes.
commission.
Yes, because it would make sense that the department itself, an agency, can't go after an agency, but that individuals and nonprofits and public interest organizations could,
But
right?
That
Yes.
is not the law as it has been interpreted by this court. And
I
it
understand
should-
that it's not the law that it's been interpreted, but it seems to be the law that is on the books.
Well, Your Honor, while we disagree that that is the law that's on this books, I would turn to the alternative grounds for our affirmance, because to the extent that you're going, that makes sense, it doesn't make sense here especially, because if you're looking back at whether this is appropriately here before this court, or whether this would be at the commission, I just want to clarify this issue about whether there is a forum that was created, because Your Honor, I would contend it doesn't make sense to have a CPPA claim for all those categories because of the fact that there's entirely different parallel paths where they're talking about other agencies where those actions are reviewed. Here, when you're talking about the commission has open dockets specifically addressing the documents that are at the heart of plaintiff's claims. And multiple public interest organizations have intervened and been granted party status. And the
Right.
only requirement
it-
for doing so
I
is to
guess,
have a
the-
substantial
are you
interest.
making it like a preemption argument then?
No, Your Honor.
Okay, because I mean, like, I get that the Public Service Commission might have broad jurisdiction and that individuals or groups could go there. That's great. But the question is whether or not this collection of groups can go to Superior Court under the CPPA. And so the fact that there are alternate avenues, like, I'm not sure where you're going with that unless you're making a preemption argument.
No, we're not making a preemption argument. I'm responding to the repeated assertions by counsel that if they are deprived of the ability to bring a CPPA court claim in
Right,
this.
I mean, that seems atmospherics at best, right? Like, unless there's a preemption argument, which I hear you're saying you're not making, this is really a textual analysis. Does the CPPA allow for this or not? Did the council authorize these sorts of actions or didn't they? And that's the question.
Well, and Your Honor, we believe they did not. And again, I believe Hormel is a very interesting or notable case on this point, because it does actually talk about what the point of 2012 is, and to the extent that you are focused on this, what is
Right,
the new
but
statute?
with the focus, I mean, again, I think it's so important what the judicial mind is focused on, and there, Hormel, the court is looking at standing, and it's not, I mean,
That's correct, Your Honor, but it's saying what was the purpose of the 2012 amendments? Because that's fundamentally what you're saying is, did they remove a limitation to the scope of the CPPA? And this was the reasoning in Gomez, where they said, more importantly, there was no evidence that they intended to change the scope of the act by making the
right,
substantive
and we
amendment.
have them on, we heard the language where they're saying part of their intent is to make clear that C2 only applies to the department.
For 2018 and landlord tenant, Your Honor. That's not the
I mean,
same. as-
regardless, we have a statute that incorporates all of these amendments that make clear that the council perceives the CPPA to have two avenues. One for this consumer protection agency to do its thing, and one for a private right of action. And they don't overlap, and they're not coextensive, and private actors and nonprofits and public interest organizations can perhaps do things that the department, for good reason, can't do or doesn't want to politically.
Your Honor, there's no indication on the text of the 2018 amendment that that was what was intended by amending to add landlord tenant into the statute. If anything, the opposite inference is true, because they would not have needed to make that amendment if the 2012 amendment for standing removed the limitations on the scope of the CPPA. They simply would not have needed to make that change. Thank you, Your Honor.
Thank you, counsel.
I think that they did need to make that change, and they told us why they did in the emergency resolution. The fear that a court might wrongly interpret the department as precluding other actions. And I'm glad that 3905 K6 was brought up. Because importantly, when 3905 K6 added to say, you know, landlord-tenant relations, go for it. The provision from 3903 C2A wasn't changed. So still, department, don't go for it. Others, go for it. It is clear that the council sees a distinction between the department and other parties, and especially a party like a private attorney general who's been given this wide berth to bring such actions. And if I could further quote from the emergency resolution in 2017, the council stressed the importance of not misinterpreting this point so that district residents are not potentially robbed of the full protections due them under district law. And that was said in the context of the attorney general being able to bring a claim. And yet here we are 7 years later facing an argument that a provision limited to the department should be expanded to include private attorney generals from acting, thus robbing district residents of the full protections due them under the law, precisely what the council feared. And if there's no questions, I would ask the panel to reverse the grant of dismissal and remand for further proceedings. Thank you.
Thank you, counsel. We appreciate your arguments today, and the case will be submitted. The third case on our calendar today is 24 CV 397. I'm going to wait to let people clear out of the courtroom and sit down. The third case on our calendar today is 24 CV 397 Charles E. Wilson versus Muriel E. Bowser et al. Counsel, whenever you're ready.
Thank you, Your Honor. It please the court. My name is Johnny Barnes. I'm counsel for the appellants in this case. And if the court will allow me, I would like to take 12 of the 20 minutes allotted to the parties to make the case for the appellants and reserve 8 minutes to respond to both appellees, including the amicus, for rebuttal. Thank you.
Wasn't aware that we had given 20 minutes per side, but I'm sure we'll give you enough time to make your argument.
Sure. I think we start with the text, the statute on which the trial judge relied to dismiss the case. That statute gives a party who wants to challenge what the DC Board of Elections has done 10 days to do so. And the trial judge read that to mean you have 10 days to start and 10 days to finish. We don't think that's a fair reading of that statute. We think that there is indeed a ceiling. You have 10 days to finish, but there is no floor. You start before the 10 days is of no prejudice to the appellees, because case is not considered until the matter is filed in the DC Register. But the summary, the short title, the legislative form of the proposed initiative 83 was ready and had been finalized far in advance of September 1st.
So counsel, am I correct in thinking that you agree that DC Code 1-1001.16 EA1 applies to your complaint?
It
But-
applies only as to the summary, the short title, the legislative form of the proposed initiative. The complaint had several components.
In fact,
That-
it didn't really challenge the title, the summary, the form, did it? It seemed to be entirely about whether the initiative was a proper subject for an initiative.
Mostly about that.
But don't you need to have the initiative kind of in formal language before you know what the initiative is about? I mean, I get it that the Board of Elections discussed the subject matter of the initiative at the July hearing.
And
then-
finalized it.
Well, I think they finalized the language at the August hearing, right?
Mhm.
I'm reading the transcript. That's at the end of the hearing. They read out what the notice is gonna say.
Mhm.
And so that's, are you saying that as of the July hearing, you had a right to sue then to challenge the initiative as being initiative worthy, if I can use that shorthand? Don't you think you should have to wait until the actual language of the initiative is formalized to then bring a case? That seems like an awfully sort of unwieldy system where you could go to court on the initiative worthiness first, and then you can go to court in this limited window of time just for kind of formalistic purposes to challenge how the initiative is being summarized or its short title, or is that what you're saying?
We did wait, Your Honor, until.
I understand that you did. I'm trying to understand how you're interpreting the statute. So I know what happened and what, I think waiting makes sense, all things considered.
The
But I-
statute also says it should get expedited consideration. That's where the 10 days comes in, I think.
Right. But I'm still trying to figure out whether you're saying that 1-1001.16 E1A applied to the complaint that you filed.
Well, it did not comply or apply to the whole complaint. There were other parts or other counts. to the
Because you're
complaint.
saying you were doing you were not just challenging the summary statement or the short title.
That's correct, Judge.
But that gets me back to my question of why would it make sense to allow you to sue without any time frame before the language has been finalized at the August hearing, after the July hearing, where the substantive decision is made, yes, this is initiative worthy?
Because there's no requirement in I want to make about 6 points that I think packaged together reflect why the dismissal of the whole case, including
Right,
the
but
other.
can we just stick on the statutory interpretation issue? I just don't understand why E1A isn't signaling, just wait until, like, we understand that maybe the decision, the substantive decision that this is initiative worthy might have happened earlier in time, but we'd like you to wait until the language of the initiative is actually drafted and approved. And then you have 10 days to bring all of your challenges.
Well, as Your Honor said, if you go to the text, it doesn't say that. It does say you have 10 days from the time
Right,
that.
but why wouldn't it be an absurd? I mean, yes, we do have to look at the text, but we do have to resist absurd interpretations of the
Exactly.
text. And it would seem to tend in that direction to say, sure, sue without any limitation, no timeframes whatsoever. And even sue twice, right? Like you can have a separate action on whether or not it's whether it's initiative worthy. And then you have this more limited formalistic action that falls under E1A to talk about your complaint that the short title isn't drafted exactly how you want it to be drafted.
Well,
Why does that make any sense?
well, it makes sense because the appellees had time to respond beyond the 10 days, and they did.
No, but why would it make sense to bifurcate it like that?
Well, because the language, the text doesn't require that you file immediately on the day that it's in the register. In fact, the rules of this court, when interpreting electronic filing, Rule 25, says that if you file the case on a day when the court, if you file it electronically on a day when the court is closed, then the counting doesn't start until the next day. You know, COVID and electronic filing ushered in new normals. And then Rule 6, which is not a new normal, it's been the situation in DC Superior Court forever, says you don't start counting on the day of the event, you start counting on the next day. And that's why the docket put the date of September 1st as the filing of the complaint, not the e-filing that was done after the court was closed. So you look at those two things, and I think that
When you say the docket said it was September 1st,
the court's docket.
yeah, I just,
It's in our brief, Judge.
well, you said that in your brief,
Yeah,
right? But you didn't give a record citation and
I've
in
put a
the
copy of the docket.
in the record materials, I mean, maybe I'm looking at the wrong thing, but what I thought was the docket seems to reflect that the complaint was filed on the 31st.
The docket reflects complaint was filed on September 1st.
Right, I'm not quite sure where I'm supposed to be looking to see that,
Okay.
but I
don't know
might be
exactly.
missing something.
I don't know exactly what page it's on in the brief, but I can show you a copy of.
Right, I saw it in the brief. I just didn't see a record citation in the brief.
Yeah. This is from the docket of the trial level case, Judge. September 1st. The judge was not assigned until September 1st. The initial order was not issued until September 1st. Nothing happened on this case on August 31st. And Rule 6 says you don't count the first day that something happens. Count the next day. That's what I had been accustomed to, Judge, in all the years I've been practicing law. Shall I proceed, Judge? Thank you. So if you look at the text and a fair reading of it, that's the first point we want to make. We don't believe that that there's any language that requires that you rush to the court and file on September 1st. And then you have 10 days before anything happens. In fact, nothing happened in 10 days.
Am I correct in thinking that what was published in the DC Register was the same thing that was on the website, the Board of Elections website?
Yes. Yes.
Which was the same thing that was read aloud on August 23rd.
Yes. That,
Well, maybe not the same thing because I think they just read the summary aloud at the August 23rd, so they didn't have the full.
yeah, they didn't read
The
the
full
whole
text.
So you put those two things together, and then you put together the fact that the complaint had other parts to it. It wasn't just about the summary and those other items that the Board of Elections had to publish in the DC Register. It was about the Home Rule Act. It was about the Constitution. It was about several counts that had jurisdiction independent of the actions of filing the with the DC Register. In fact, the complaint heading says that. It lists that it's protesting the summary statement, short time legislative proposed initiative 83, as well as several other counts, and they're all in the complaint, and they all had an independent jurisdictional basis.
You know, speaking of jurisdiction, do you think that the statute we're dealing with, 1-1001.16, is a jurisdictional statute?
No.
Or is it a claim processing rule?
It's a claim processing rule. In all the cases, Your Honor, say that when it comes to early filing, exhaustion doesn't apply really, rightness, to dismiss a case on a jurisdictional basis. It's not jurisdictional to early file. It's jurisdictional to late file. And that's why I said, you got to look at the text of the statute.
You think it's jurisdictional to late file?
Well, if you late file, you're out of court.
Right, but that could be a claim processing rule, right? I mean, we've said that jurisdictional language is usually, the statute says a person may seek review in Superior Court within 10 days. We've said that's not really enough for a jurisdictional bar. Jurisdictional language is things like an appeal may not be taken, no person shall file or prosecute, no action shall be brought under that sort of language.
And that's why,
jurisdictional language.
and that's why it relates to late filing, not early filing. And all the courts have said that early filing does not deny access to the courthouse doors. And I've cited a number of cases throughout the brief on early filing. Of course, beginning with the Stewart case, the Darby case, the Lemke case. In fact, in the Darby case, Supreme Court case, Justice Goldberg said that, this is not about technical maneuvering, that it's about getting to the merits of the case. And so if someone early files, they ought to have an opportunity to be heard in court.
If you had been advised that the Board of Elections thought that your filing was premature within the 10-day time frame, would you have refiled?
If I had been advised by the Board of Elections?
Yeah, or would you have just, right? I mean, they didn't file their motion to dismiss until
The government has.
a while later,
more
by
than-
which time the 10-day period had elapsed.
Mhm. Yeah, and the judge didn't rule on it until 7 months later. You know, when the statute requires expedited consideration.
Counselor, here's what I want to ask you. Suppose we agree with you that this was not a jurisdictional, this is not a jurisdictional statute, and the court erred in dismissing the suit for lack of jurisdiction.
The host.
Suppose we agree with you. What should we do? And I ask this question because your brief says that the complaint provided sufficient information that outlined the legal elements of viable claims that would have been supported at trial with any required factual evidence, even though the claims presented questions of law. And my question goes to that last clause, even though the claims presented questions of law. So to start my question again, if we agree with you that this should not have been dismissed, should we send this back to the Superior Court to deal with your merits challenge to whether the proposal was a proper subject of initiative? Or since you say the claims presented questions of law, should we resolve them ourselves?
I think the court is empowered to resolve, it's de novo review on a dismissal. You're empowered to resolve it yourself. But there are some matters that had they been explored, would have presented questions for the broader complaint. Like, can you change the charter of the Home Rule Act through initiative?
Well, but did your complaint raise issues that required the development of factual evidence? Because obviously we're not going to conduct an evidentiary hearing and develop any facts here. Is this a matter, did your particular complaints require development of the factual record such that we should not resolve this?
I don't know that there's factual matter that to which a jury would get involved. Although we did make a jury demand on at least one of the counts in the complaint. And I think this court can resolve this without probing the facts.
Did the Board of Elections already pass upon all of your claims? I know they had a hearing. I can't recall, frankly, whether you testified or not. Did you?
No, I did not testify.
Did anyone testify and present your issues?
I believe some of the issues were presented. And quite frankly, I think that at least my clients were surprised that the initiative went forward, given the disabilities with it.
What I'm getting at is, do we already have the benefit of the board's thinking on the issues you've raised?
No, not all of them. Not all of them.
For example?
For example,
Which is one as to which we do not have the benefit of the board's thinking?
I think one of the more powerful complaints or counts in the complaint is goes back to the Heckinger case, where there was a challenge as to whether the Congress of the United States, the District of Columbia is not a sovereign authority, as Your Honor well knows. We're not a state, unfortunately. The Congress is the last word. And when the Congress says you gotta have partisan elections, we gotta have partisan elections. And to allow that apparatus to be interfered with without the process is established in the Home Rule Act and the Charter, which is you do it, the council has to act first, and then you have a referendum. You don't have an initiative. And then it goes to the Congress. The Congress has the last word. They can tell us how to live and tell us how to die. We can't decide that what Richard Nixon signed in 1973 will be different than the way we conduct affairs in the District of Columbia. We just can't. We don't have that power. And this initiative goes after partisan elections, which was established, the apparatus for that was established by the Congress. We can't change that.
Well, the board did have some things to say, though, about whether or not the result of implementing the initiative would be not meeting the requirement of partisan elections. I mean, they said something about that. Yes? Are you saying that your claim raises some angles on this or raises some aspect of that the board did not consider?
Yes, it does. And that's, you know, as I said, that's the Heckinger case. And that ruling was written by Judge J. Skelly Wright, who was certainly conversant in these areas. And he said, you can't change what the Congress has done, not by initiative, anyway.
So do you feel that issue is one that's ripe that we could easily decide as a matter of law without the board's thinking?
Well, you're gonna get the board's thinking today. But I think it can be decided as a matter of law. If you look at the Home Rule Act, the charter, it's clear. And if you look at the power of the DC government, given its status, it's clear. You can't change how the council is elected through initiative. And that was one of the counts. I think the parties raised exhaustion and rightness as issues. And again, there's case law, a whole body of case law when it comes to the question of early filing, not late filing, but early filing. And that's 1 day early, according to their count. We would say, according to the rules, it was timely file. That exhaustion and rightness are really not impediments to early filing. And this is from the Supreme Court on down, that you don't have to wait on the administrative agency to finish its work. You can move on doing something against what the agency contemplates or is involved in without waiting on it. Exhaustion is not an issue, nor is rightness. You know, it's the Burton case. And I believe the court sat en banc on that case. That's the Zipes case. That's a Supreme Court case. Well, the Burton case was a DC Court of Appeals case. So when you package those things together, the fact that the statute, the text of the statute does not say an early filing is forbidden. Simply says you got 10 days once that date of publishing in the register is done. And then the rules of this court and the rules of the DC Superior Court say you count starting the next day. And so those are express rules, and the rules.
Counsel, I think we have your argument.
Okay.
And we're going to let you sit down and we're going to hear from
Thank you,
appellees, and we'll give you a little bit of time on rebuttal.
thank you.
Thank you.
Aspirate and
I neglected to ask how the time is being allocated.
We said we were going to take about 8 minutes.
Okay. Board of Elections is going first. Okay. All right.
Morning, Your Honors. I'm Christine Pembroke with the DC Board of Elections. Here with me today is Terry Stroud, the board's general counsel. Before this court is a simple, straightforward matter as to whether the Superior Court properly found that appellant filed his complaint below outside the statutorily prescribed window for seeking judicial review. By his complaint, appellant sought to challenge a ballot initiative, initiative number 83. The election laws provide a specific delineated ballot access process for initiative matters. Noteworthy steps in that process are include the board making a threshold decision as to whether an initiative proposal meets certain proper subject matter requirements. If the board finds that it does, the next step in the process is for the board to formulate the measure by, among other things, putting it in legislative text, adopting a title and a summary statement for inclusion in the ballot. By law, the board must publish the final measure formulations in the DC Register. After a measure overcomes proper subject and formulation hurdles, DC Official Code 1-1001.16E provides that any DC voter who objects to the measure may, quote, seek review in the Superior Court of the District of Columbia within 10 days from the date the board publishes the summary statement, short title, and legislative form in the District of Columbia Register. The plain and unequivocal language of this provision is that the challenger of the measure must wait for the DC Register publication before going to court. In this case, appellant did not abide by that statutory requirement.
Counsel, what's the harm?
Well, the harm in this particular instance would be that it's possible the final formulations did not include language that might have been at issue in his complaint.
And that would be prejudicial to them though, right?
That's possible, but it also creates a problem for litigating that you have a case that's being processed in a ballot access process that has to be completed in a set time before the election occurs. And
Outside of the hypothetical universe, in reality here, there was not a difference, was there?
there was not a difference in this particular instance. That's correct, Your Honor. But the fact of the matter is there was no excuse for him to miss that deadline. He was warned of it twice by general counsel at the hearings in this proceedings. In fact, on the August 23rd hearing, she said specifically on the record, this is going to appear in the DC Register on September 1st. And that's an important date because that's the day when you can go to court.
But
And
I mean,
he
she
did,
also says, I think it's in that same proceeding, that's at the July hearing, right?
that's the August 23rd hearing, Your Honor. The July hearing was at was with respect to the proper subject matter determination. We didn't know at that point exactly when the formulation would be made. So she sort of just outlined what
No,
the next.
that's an important date. That statement is made on July 21st, I believe, since supplemental appendix 254. And she says that within 24 hours after that public meeting, referring to the August 23rd meeting, we would publish the summary statement and formulations and fiscal impact statement on our website and submit it to be published in a newspaper of general circulation. And we would also publish the formulations in the DC Register, and that's an important date because it does trigger a period during which the formulations can be challenged. And what I thought was interesting is what ends up happening, is that I guess the language that is formalized on the 23rd is immediately put up on the website and is the language that ends up being in the initiative. But for whatever reason, it takes a while to get into the DC Register. And I'm wondering, I mean, maybe the Board of Elections abided by the requirement under 1-1001.16D2 that they submitted the summary statement within 24 hours to the District of Columbia Register for publication. What took so long to get it actually published? Does it only come out once a week?
Yeah, so I believe
Okay.
the DC Register comes out bi-weekly and you can only submit up till Thursday of the week before the Friday that the publication comes out. So depending on when the board submits something to the register, it will either go in the next DC Register.
Yeah, except that this
publication
took
or the
like
next-
10 days, right? I mean, I think that the August 23rd was, I had these dates.
It was submitted
But
within the
it was
24
like
hours.
Yeah,
And then
but
the
it was
register,
submitted like on a Tuesday and it didn't come out until the following Friday.
that's correct. And that's the way the DC Register process works.
Okay.
So
But-
whatever was
But
submitted on
one
that.
could see how that could be confusing, right? That you see it on the website and you think, okay, it's there and it's exactly what the language that's on the website is exactly what was read aloud at the the August 23rd hearing.
Okay, I would say two things about that. First of all, this court has been very clear that the deadlines and the timeframes in the statute are strictly applied. And we have had instances
When
where
they're late, right? When they're late. Have we ever had
No,
a
yeah.
premature?
We did, yes, in Lawrence, and in the Lawrence case, there was a challenge to, it actually was Mayor Barry's residency. And it was filed before the challenge period started.
And did we say,
And-
were we interpreting this statute and did we say that it imposed a jurisdictional bar? Because our views of jurisdictional bars have changed quite substantially
I don't think any,
following the Supreme Court.
yeah, I don't think any of the cases involving the election laws speak to whether it's a claims processing or jurisdictional bar. What those cases all say, irrespective, is that the timelines are strictly in.
Well, they may be strict, but it matters, right? And what's the Board of Elections position? Do you think that 1-101.16E1A is a jurisdictional bar?
I think it has to be a jurisdictional bar, because if we start to allow all these deadlines to be waived, the board will not be able
Well,
to.
there's a
to
difference,
carry out
right?
an
I mean,
election.
there's a difference between saying it's a jurisdictional bar and it can't be equitably told ever. And saying it's a claims processing rule that can be enforced, the opposing party can invoke it, as the Board of Elections did in its motion to dismiss. But then there's still some ability to say, we're not gonna hold their feet to the fire by the court. And I guess I do call your attention to the Fraternal Order of Police decision from 2022. It's 277A third 1272. The pin site's 1279, where we talk about examples of jurisdictional language that just do not map on to this statute, which is someone may sue within 10 days versus if you don't sue within this time frame, no action can be brought.
I understand the distinction between may and must, but in the context of the election laws, which is a unique area of statutory application, this court and other courts have been adamant about the fact that the timelines in those statutes have to be strictly applied, regardless of whether they use.
If I can just ask you to help me make it make sense. I get the idea of it being jurisdictional and we should strictly apply those and on the late end. That holds you up. If someone turns their homework in early, I don't see where the harm is. And that was why my first question was where the harm is. Because that's now teed up and ready the next day in this case when the 10 days begin. Like, it doesn't slow you down in any way. So why should it have the same preclusive effect that someone is diligent?
Well, for the same reasons that the court discussed in the Lawrence case, that you end up with this piecemeal litigation, which just interferes with and hampers the whole ballot access process for everyone. And that's what the court said in
Where do
Lawrence.
we end up with piecemeal litigation on this, right? Like, if this is not a jurisdictional statute and we say it's a strict claims processing rule, but it can be equitably suspended under the appropriate circumstances. In a situation here where nothing changes about the text that's on the website posted by the BOE and in the notice that is published in the DC Register, the complaint is filed 1 day early. Under those, why would we not say, as an equitable matter, we're gonna suspend that deadline? We get that you guys don't like it.
Because the statute in this case is clear as to when.
I understand that the statute is clear. That's not the question. The question is, why
and
wouldn't
in
we
this
equitably
case-
suspend it?
In this case, the opposition is represented by experienced counsel who should have known what the statute said and should have understood what general counsel said twice on the record about when the case could be properly brought. There are no equitable reasons here for waiving that statutory requirement. They weren't misled by anybody. This isn't a pro se litigant. If the court is going to read this as simply a claim processing statute, there are no considerations here that would warrant ignoring the language that the
Well,
council
here's
has
a
adopted.
possible consideration. I mean, is the statute clear that the 10 days applies to an opponent's challenge to whether the proposal is a proper subject of an initiative? I mean, it talks about, I thought I had the language right in front of me, but I think it says if you object to the formulation or the short title, then you have 10 days, or you may within 10 days sue to challenge the short title, the summary, the formulation. Does it mention proper subject?
So the statute, I think, is clear if you read it in context, and that is that it starts out by saying, once the board makes a proper subject matter determination, the proposer, if they're adversely affected by that, can
Right.
go to court in 10 days.
What does it say about the opponent?
It says nothing about the opponent because the rationale for the statute read in context, if you read those provisions in tandem, is that the opponent has to wait until after the formulations are made in order to go to court, so that you don't end up with piecemeal litigation by the opponents, which is exactly what is
I
happening
take
in
your
this
point,
case.
but if we're strictly going by what the statute says, I don't think it says, does it? That the opponent may within 10 days challenge the proper subject of an initiative. It just doesn't say. And it makes me think that this may be a case like one of our other cases, Hesse, where we talked about the Superior Court's equity jurisdiction.
Well,
Why did the court not have equity jurisdiction to hear a challenge to whether this was a proper subject of an initiative?
So Hesse is different because in the Hesse situation, the case was actually brought within the statutory timeframes, and the issue was whether or not interveners in that case could make an equitable claim for relief. So what the court, I think, in Hesse said was that if you come into court properly within law, then you can get equitable relief, which makes sense because the only kind of relief you're really getting from a practical standpoint, you're not getting money relief in a ballot access process case. Your remedy is essentially equitable. In this case, they didn't come into court in accordance with the law. So there is no jurisdiction in law by the court in this matter. Therefore, they wouldn't be entitled to any kind of.
What happened in Hesse was, well, a lot of things happened in Hesse, but the groups that tried to intervene or that did intervene, I think, in a proceeding in Hesse, then later brought litigation, and the court said something like these are equity plaintiffs. They're now equity plaintiffs challenging the
Right.
proper subject.
Right.
It's not clear to me why our appellants here could not be equity plaintiffs proceeding on their claims about
But-
proper subject matter.
But again, the only reason why the court entertained those claims was because the case was initially brought properly under law.
But
within
not by the, I
timeframes.
mean, the interveners just intervened. They didn't bring it. They
Right.
had no mechanism for bringing it.
Of course. But the point I'm trying to make is, and I think Hesse says this very clearly, is once the case is properly before us under law, we can go ahead and reach these other questions. And in this instance, the case isn't properly before the court under law because they did not file within the time period that was prescribed.
Well, counsel, let me ask you separately then, because I know we've really kept you on this topic. I gather from the briefing that this is your position, but just to be absolutely clear, is it your view that if we did decide to go and reach the issues, we could decide these as a matter of law, and that's what the Board of Elections would want us to do?
Yes, absolutely, Your Honor. If the court did want to move forward and address the merits of this case, we are absolutely 100% confident that the board made the right decision on the proper subject matter questions.
But are
which
we reviewing the board's decision? I thought we were reviewing the Superior Court's decision.
So,
And the only basis of the Superior Court's decision was this is untimely. So
Yes.
we're the court of review, not first view. Why wouldn't we send this back to the Superior
So
Court?
I think that this court has authority to do either. There are
Where
cases.
is that authority?
So there's cases cited in the brief, in our brief at footnote 4 that talks about some instances where the courts have, the Supreme Court made decisions on the merits of matters rather than remanding them. And I think that you would have the authority in the interest of judicial economy, since you're reviewing the record of the agency.
But we're not reviewing the record of the, I mean, or correct me if I'm wrong, but tell me, like, I see DC code 1001.16 E1A to say, hey, if you don't like what the board did, you can sue. And it's not saying go to Superior Court and litigate about whether the board was right or wrong. It's go to Superior Court and litigate whether or not this is the proper subject of an initiative or whether I mean, I don't see any deference to the board. Like, this is like, you have a private right of action to go and say, this shouldn't be on the ballot. Or am I missing something?
Well,
This isn't an
assuming they filed
agency-
timely, they could have gone to the Superior Court
Right.
and brought an
So you
option.
go to Superior Court and you file your complaint and you litigate your complaint. And we don't have any of that litigation before us because the Superior Court said this
Well,
is untimely, you're out of here. So why would we, as a court of review, then step in and say, oh, well, let us in the first instance review all of these issues ourselves? We don't do that.
Our position would be that either court, whichever court is reviewing the agency record of the proper subject determination.
But it's not where we're not, that's my point.
Well-
And maybe I'm wrong, right? And so I'd be happy for you to tell me what authority I should be looking at to say that I'm incorrect. But I wasn't understanding this right to sue under the DC code provision that we're talking about as an agency review action. I was understanding it to be an independent action to say, this thing is not initiative worthy, it shouldn't be on the ballot. You know, you Superior Court, I want to take this to a judge and I want the judge to decide that this isn't right. And we don't have a judicial decision, yay or nay. And now you're saying, well, that doesn't matter. You guys can just decide in the first instance. Am I missing something?
I don't think you're missing anything, Your Honor. Let me say that I don't think this court is precluded from reviewing the agency's decision, and I don't
But
believe.
why, but I'm sorry, you keep saying precluded from reviewing the agency's decision. We don't have jurisdiction over the agency's decision. We have jurisdiction to review the Superior Court's decision. The only decision the Superior Court made was to say that this complaint that was filed was untimely, right? I mean,
So-
it's like Walmart fires a worker and someone goes into court and sues, and the court says, statute of limitations, I'm sorry, you're out of here. And the plaintiff comes up to us and says, statute of limitations was wrong. We'd like you to review whether Walmart was correct. And we say, no, we're not going to do that. We're going to send it back to Superior Court for the court to decide your claims in Superior Court.
If this court feels that it does not have jurisdiction to decide the proper subject matter merits issue, and it elects to remand, we have no objections to that because we're totally confident that the board made the right decision as to proper subject matter.
If the Superior Court had not dismissed this action and had addressed the merits of whether the proposal was a proper subject of initiative, would it have been limited to whatever was before the Board of Elections at the time it made its determination to accept the initiative, or would it have been free or obligated even to take new evidence about pertinent to the various claims?
I believe that the law is clear that and the cases that have come before in which the Superior Court have reviewed initiative matters is that as to the proper subject matter question where there has been a hearing and a record developed and the board has issued an order on proper subject matter making proper subject matter findings, that the Superior Court's review would be limited to the record before the agency and the agency's.
Yeah,
order.
that's, your
I don't-
comment is reminding me that one of the claims brought in Superior Court was that the board did not make findings of fact and conclusions of law. Maybe that's what that one was about. It had me scratching my head at first, so maybe that's what that one was about. But this was not styled as in the Superior Court as an action for review of an agency action. And most such actions come directly to this court, as you know very well, but there are some that do not,
Right.
such as appeals of decisions of the Office of Employee Appeals, for example, where the
Goes directly.
Superior Court, goes directly. And then when we review not the Superior Court's decision, but the Office of Employee Appeals. And I'm just trying to think through what would be the case here. So you're thinking that if the Superior Court had gotten to the merits, it would have essentially been reviewing the
Agency record.
agency record.
And do you
Yes,
have anything to cite to us statutorily
Well,
to say that that's what happens?
well, the statute just,
I
it
mean, because there
addresses.
are other, to Judge Thompson's point, there are other cases where we say they're agency decisions, they're not contested cases, that you don't have a right
Right.
to go under the APA, but you can go to the Superior Court and litigate that case. And those are new cases, right? And so the Superior Court makes a decision on those cases and then it comes up here and we're not reviewing, I think, we're not reviewing the agency's decision, we're reviewing the Superior Court's decision.
I don't think that the statute expressly states that it's limited to the agency record, but the case law clearly are situations where the Superior Court has just reviewed what the board's
And
finding.
those
So I don't
cases
think-
are in footnote 4 of your brief?
Oh, no, they're not in footnote 4. We did not brief this particular issue, Your Honor. I can provide supplemental authority to the court if the court wishes to see that.
Sounds like a really good idea to me.
Okay.
Sorry to interrupt you.
So I think we've covered all of the points that I wish to address. I would just close by asking the court to affirm the Superior Court's ruling that the case should have been dismissed for lack of jurisdiction. And I will try and get some supplemental into the court shortly.
Thank you, Counsel. Sure.
Morning, Your Honors. May it please the court. Kevin Hancock of Campaign Legal Center, representing Amicus Curiae, Make All Votes Count DC, the proposer of Initiative 83. Counsel for Appellees and us conferred before, and we had agreed that we would take 7 minutes, and I see that's what I have here. So thank you. And also, I want to take this opportunity to
7 minutes, more or less.
Yes, 7 minutes for me.
And the district is or is not arguing.
My understanding is the district is
all
here,
right,
and I
very
believe we agreed that they would take 3 minutes, but I don't want to get ahead of them, of course.
Great, thank you.
Thank you for the opportunity to argue here before Your Honors today. So we agree with the board that this court should affirm the Superior Court's ruling that appellants untimely filed their suit, and that this is a pretty straightforward case. And that given that untimely filing, there is no need for this court to wade into the merits of appellants' claims against the board that they incorrectly decided the subject matter of initiative issue. But in case the court would find it helpful, we're happy to explain why we believe it would be appropriate for this court to rule in favor of the board on the merits on those claims.
Can you just explain to us procedurally what happened? I mean, I would love to be refreshed on the record, sort of what happened at the July hearing. I didn't recall that there was some sort of adversarial proceeding where the opponents of this initiative got up and argued before the board, but maybe I overlooked that.
Well, the board did have a hearing in July of 2023 where
Yes.
opponents of the initiative were allowed to come in, make comments, present evidence, explain why they believe the initiative was not a proper subject matter. That those comments, that evidence, I think a lot of it's just kind of assertions, but it is in the supplemental appendix that the board has filed with the court.
But can you describe that proceeding? I mean, was it in the nature of this sort of argument where, you know, the proponent got up and said, this is, or you got up and said, we would like this initiative, we think it's initiative worthy, and then others got up and said, no, it's not, here's why, and the board asked questions and then said, okay, now we've made a decision?
Well, so I'll confess not having been at that proceeding, but like that is my understanding of what occurred there,
Okay.
right? So people had the opportunity to speak, to submit written comments. Those comments appear in the record before this court. And so.
Right, but the opportunity, I'm sorry to press you on this, and
Sure.
I can go back and look at the record again, and I will. But there seems to be a difference between giving people an opportunity to speak, sort of, hi, I'd just like to say that I don't like it because of X, Y, Z, or I'm a big fan because I think that this is a great idea. And having this sort of presentation where you have a proponent and then opponents and then an actual decision. Do you think that's fair?
The latter is my understanding,
Okay.
yes, and I believe that is fair. And yeah, that's my understanding from the record, Your Honor.
Thank you.
On the issue of whether the court can and should rule on the merits at this point, I think we're in agreement with the board that the court could and should. Although we also agree with the board that if the court feels it's more proper to, if it's inclined to reverse the Superior Court's decision, that we're not opposed to a remand and then litigating the merits before the Superior Court, and like the board.
Do you have a view of what is supposed to happen in Superior Court? When someone files a complaint, is it supposed to be a review of what the board did? Or is it a new kind of, hey, here's the law on what can be an initiative and we would like a judicial ruling that this is not okay?
I think it has to be an administrative review case, a review of what the board did and whether, according to proper deference, what the board did was or decided was correct or not. And there are a couple of reasons for that. One, I mean, it had like that review has to be grounded in the record, in the administrative record that would be before the Superior Court, and that's before this court now. But also, if the claims were just standalone, unattached from anything that the board had done, then you just have like a standalone challenge to the legality of something that is not law yet, and by definition would be unripe. Of course, you could have a situation like what I think this case is, where you're reviewing what an administrative agency did and arguing, okay, we think that was wrong. Or of course, like claims are brought all the time against enacted laws, claiming that they violate someone's constitutional rights, or they violate this law and that law and have imposed an injury on a claimant. My understanding of this case is it's the former, an administrative proceeding. And if it was the latter, if it was a standalone claim, there would, I think, clearly be no jurisdiction in the courts because it'd be unripe.
Do you have anything in the statute to point to us in that direction? Or is it really just our case law that gives you that impression? Or
I think my impression of that is from the very complaint. This complaint is styled as a challenge to the board's decision on its formulations, and it cites that provision with the 10-day period in the laws governing the board's procedures.
And sorry, I don't quite follow your unripeness point. I mean, because if the argument is this just shouldn't be on the ballot, it doesn't qualify to be on the ballot, why is that not a right for decision? The board has said it can be on the ballot.
Well, I think that scenario is right, but that has to be a review of what the administrative agency did.
Why?
Because they're the ones.
I mean, why couldn't it just be, I mean, because there are cases where we say, okay, somebody, initial decision maker makes a decision. Now we're going to give it to a different decision maker, and we want you to make it. You are a judge, you make the decision. And why isn't that this scenario?
I think in that case, it would render the board's procedure for making this decision almost beside the point. They're the agency with the expertise.
Not necessarily. This does happen, and I'm not coming. It's not coming immediately to mind the scenarios in which it does, but it does happen where we sort of let a preliminary decision maker make a decision, and then we say, okay, if you don't like it, you can go to a different decision maker, and here's the structure for that, and then we review the second decision maker.
Well,
that's not unheard of.
I would say I take your point that it may not be unheard of. The relevant statute here doesn't provide for that. And so in the absence of that kind of specific guidance, the default understanding, I think, should be that this is an administrative review case. And, I think there are probably prudential reasons for why that makes a lot of sense. Again, the agency has the expertise here. It knows its statutes the best. The court, the agency is entitled to deference from the courts
Well,
on those.
maybe it's an administrative review case, but do you think it's clear that the Superior Court has to defer to the board from the statute or anywhere else?
My understanding from the case law is that the board is entitled to deference on its decisions of law to the extent that they're not plainly wrong, and on its findings of fact, so long as they're supported by substantial evidence.
Okay.
And again,
That's
that makes a
under our
lot of
case.
sense given the agency's expertise. There are a few reasons why the court should, I think, again, this is assuming a world in which the court disagrees with the Superior Court's decision on timeliness, that it would be appropriate and would prudentially make a lot of sense for this court to take up the merits issues now, mostly because of the public interest in the ongoing election. Voting has already commenced on Initiative 83. Ballot drop boxes are available. Early in-person voting will start in just a few days, and the election itself, of course, is in just 14 days. The board's decision determining that this initiative is a proper subject of initiative was now 15 months ago. I think there's a public interest in finality here over this issue, especially given the ongoing election, where if this just concludes that it can take up the merits now, given the record before it, that it should do so and that it should rule in favor of the board on the merits. Your Honors, addressing those merits, if the court would find it helpful. Taking a step back, I think it's important to remember two things, big picture, when thinking about the merits of this case. First, at bottom, appellant's complaint presents what amounts to a policy dispute about what is the best way to conduct an election in the district. But we would submit that that decision is before the people of the district right now who get to vote on Initiative 83. And this suit should not be a vehicle for undermining the power of the district's voters in order to decide that very important public policy matter. This court has talked about the importance of the power of the initiative, how it's coextensive with the council's ability to enact laws. That power is especially important in the context of election reform, given the understandable status quo bias that incumbent office holders may have towards the election system that put them in office. So the initiative power is extremely important in this context. The second kind of big picture thing I would say is deference to the board, but we've already discussed that. Taking the claims one by one, we believe the board correctly decided that Initiative 83 does not compel the council to appropriate funds. There's no dispute that the initiative contains a subject to appropriations clause that both appears in the text of the initiative and also in the summary statement for the initiative. This court has effectively determined in the campaign for treatment case, the Initiative 62 case back in 2005, that a subject to appropriations clause is legally sufficient. The initiative there had one, although it was only in a subpart of the initiative. So the court found the rest of the initiative problematic, did a severability analysis, determined it could not be severed. So the initiative was struck down, but the built-in assumption that analysis was one of these clauses is enough. And so that's enough here, and it makes sense because it directly addresses the concern behind the rule that says that initiatives cannot direct the council or command the council to engage in appropriations. On the constitutional claim, the associational rights claim, we also believe the board correctly decided that matter. Following the Supreme Court's rulings in Jones and Klingman, it is clear here that there is no associational rights burden under those rulings. Initiative 83 only allows independent voters who decide to affiliate with a party to vote in that party's primary. It does not allow crossover voting, which is what the Jones case found problematic. A situation where a registered member of one party is voting for the nominee of another party. That's not what would happen with Initiative 83 if it became law. The Jones case, the Supreme Court is very clear that when an independent voter is able to vote in a primary, but only one primary, and has to choose one to the exclusion of others, that's an act of affiliation with that political party. 40 states in the union allow independents to vote in primaries to some degree. So this is not a novel concept. And to the extent there's any doubt in the matter, I would direct the court's attention to the Ninth Circuit's opinion in the Democratic Party of Hawaii versus Nago case. I believe that case is the most on point case here. You also had a situation there where a party was disputing whether independents should be allowed to vote in a primary. In Hawaii, there's no party registration at all. So effectively all voters are independent in a way. They're all allowed to choose one ballot in the primary. And the court upheld that and said, look, just the fact that the party would prefer for independents to register with the party does not create a severe burden. And a severe burden is what a party must show to show a violation of their associational rights. Moving on to the third claim, the partisan basis claim, Initiative 83 would not, does not go to whether elections in the district are partisan or not. It leaves that alone. They remain partisan. It goes to how open they are. It's a totally different issue. If Initiative 83 becomes law, candidates still run as a member of the party. They still have to seek nomination, and those nominees still have to face each other in the general election. When it comes to partisanship, there's no change on that. And finally, we agree with the board's decision that there's no evidence that Initiative 83 would cause discrimination. There are assertions to that effect in the administrative record, but no evidence that would rise to the level of demonstrating a claim. And with that, Your Honor, unless you have any questions for me, I would urge the court to affirm the Superior Court.
I just have one question, just on your point about we generally defer to agencies and perhaps the board. We have case law that says that we defer to agencies when we have a full explanation of what they're doing. And here we just have, I think, and again, I need to go back and look at the July record, but I don't recall that there was a full explication from the board of, okay, we've heard all your complaints and this is why we're rejecting them and this is our analysis. And so, you know, we're allowing this to go through. I could be wrong. If that's in the record, then maybe we have something to defer to. But we don't generally defer to just an up or down unexplained decision. Do you agree?
I agree that a decision by an administrative agency needs to be explained so that the court has something to review. But I also think that that is in the record. The board did issue a written opinion and a written explanation of its decision. And it does appear in the supplemental appendix. And I'd be happy to point out the record pages.
I can find it.
So it's 269 to 280 of the supplemental appendix. And the board's reasoning is in there.
Thank you.
Thank you, Your Honors.
We'll hear from the district.
May it please the court, Sonia Lipsack for the mayor and the District of Columbia. To sustain an action against a named defendant, the plaintiff's claimed injury must be fairly traceable to that defendant's unlawful conduct. Nowhere, not in his complaint, not in his opening brief on appeal, not in his reply brief, and not this morning, has Wilson made that showing as to the mayor or to the district. That failure is a complete bar to subject matter jurisdiction that, as this court's precedents make clear, can be raised at any time. And it is fully sufficient to affirm the dismissal of the complaint as to the mayor and the district. Unless the court has questions for me, I'm happy to stand on our brief. Thank you.
Thank you, counsel. Mr. Barnes, we'll let you
Thank you.
speak for just a few more minutes.
Thank you. The prejudice here is to the appellants and not to the appellees. In fact, the appellees were helped by an early filing, if this was an early filing, because they had more time to respond. But it was not an early filing that was inconsistent, as I said earlier, with the court's rules. Not only this court, but DC Superior Court. The equitable parts of the complaint were before the trial court, and to dismiss all of the counts in the complaint based upon the trial judge's view of when it was appropriate to file the case, I think ignores longstanding DC law that equitable matters should be given some consideration. The appellants asked for declaratory relief and injunctive relief based upon the counts in the complaint, apart from the Initiative 83. And there was no discovery in this case, no motions. The judge took 7 months to simply dismiss the case, saying that you missed it by 1 day.
What might you have discovered in this case?
Well, we might have discovered, you all live in a district like I do, and there's a voter guide that's out, and 10 of the 20 pages are dedicated to Initiative 83. Money is being spent without authority. And until the council acts to give the board authority, it really has no right to spend that money. And that's what the board seems to think that folks can come into the back door where they can't come into the front door. When you're spending money, all the cases say that. Hassie Convention Center, all the cases say you can't have an initiative that allows you to spend money, and they're spending money. Discovery may have brought that out.
Do the proponents deny that this initiative, if adopted, would cost money? I mean, the argument they make is it doesn't compel the council to do anything. It essentially would be the resolution of the voters, the sense of the voters that there should be ranked choice voting and open primaries, if open is the right word. And yes, that might cost something, but the council could decide to go forth with it and appropriate money or not. So I think they're not denying that it would cost money. The question is, the legal issue is whether it is the sort of initiative that would compel the council to compel expenditures.
Apologize, Judge. There's a process for spending money in the district, and again, we're not sovereign. The last word is up to Congress. And if money is being spent to change the apparatus of electing officials in DC before the council has acted, it would seem to me that that is an affront to that process. And the council has the final word, as Your Honor points out. The council doesn't have to go along with the initiative. It can simply say no, and they may. But it would seem to me that it would be helpful to explore the issues raised in the complaint, the equitable issues raised in the complaint, to give a full picture of what's at stake in Initiative 83 that the board didn't take into account.
Did you have in mind any discovery with respect to the claim of discrimination, that this initiative would have a discriminatory impact?
Well, there are many views on that issue that have been raised before and since about that. And the way the initiative is going to work, all those counters, they'll ask you to, pick your first person from that party, and then they'll ask you to name 5 others. And there is opinion on whether or not that has a disproportionate effect on certain people. So I think that would certainly be a part of it to explore. And it may be the use of experts, I don't know. The point is that the trial judge dismissed the case, vacated all the calendar and then closed the case. So there was no opportunity to explore these equitable issues that have been raised, which have a separate foundation for jurisdiction than the statute as it relates to what the Board of Elections did in terms of sending forth Initiative 83. And I think that's the point. The 1 day early didn't hurt them. It's hurting us if that 1 day is applied.
Let me ask you, counsel,
Yes,
assuming we, excuse me, send this back down, you just heard the district's argument on behalf of itself and the mayor. And I saw in your reply brief that you continue to push back on that, saying this is an issue they're raising for the first time. Do you intend to continue to proceed against the district and the mayor if you make it back down to the trial court?
well, the mayor and the district, well, the mayor is the principal for all the agencies. And so I don't see us as really proceeding against the mayor, but the mayor is ordinarily named in cases that involve the agencies. And then the district filed a brief.
The district certainly did, but isn't the Board of Elections an independent agency?
Yeah, but you still have to name the mayor in your complaint. We're really not at odds with the mayor. The mayor didn't act on this. It was the Board of Elections. And I don't know what the appellants might do. They may not oppose, an effort by the mayor to get out of the case, but it's the Board of Elections. And let me just say that we did, Judge, raise issues about the record from the agency in terms of the DC Administrative Procedure Act and whether it was based on substantial evidence and whether, so I think those things are appropriate to the equitable relief in which the appellants were seeking. And again, the trial court threw everything out, not just the Initiative 83 concerns.
Thank you, Mr. Barnes.
Thank you.
We appreciate your argument today. We appreciate argument from Ms. Pembroke, Mr. Hancock, and Ms. Lepsak as well. The case will be submitted.
Thank you, Judge.
All around.